Said mentioning.
Link for leave to file the appeal, my lord.
When was the order passed?
My lord, 6th of May, my lord, it was uploaded on 9th of May.
Yes, granted.
Similar leave to file appeal without certified copy.
When did you apply for certified copy?
Right for certified on 25th of April.
Granted.
I'm grateful, my lord.
Let's say.
Yeah, then mentioning on your side. Appellate side mentioning.
I have to mention one matter for inclusion.
Inclusion, hand over the slip.
Leave to file appeal. Order was passed on 21st of April 2025. We have applied for certified copy on 7th of May.
Granted.
Much blessed.
Another appellate side mentioning.
One indulgence, Your Lordship, if this matter can be listed on urgent basis, this
Yes,
coming
have you filed a stay
trademark
application?
appeal. Trademark
Have you filed a stay application?
Yes, Your Lordship.
Be listed? Has it been numbered? It has not yet been
No,
numbered.
no.
Chalo, dako.
On your side non-commercial to be mentioned item number 1.
We are filing our notes. States. We'll file, not give it to Lordship's officer, not in. We're just getting stitched, not we'll hand up to Lordship's officer, not in.
Then file it tomorrow. No, without the notes, we will not reserve judgment. Not today. No problem.
Lord, in that case, with his leave, my lord, in that case, my lord, the note of arguments, my lord, which was there in the application under section 30 and 33, that contains the page number of the application under section
We'll
30 and
also
33.
get the current page.
If the lordship wants, we
Anyway,
can
give
revise
that
that.
tomorrow. Give that tomorrow.
Tomorrow.
Give that tomorrow.
Morning.
Yes, do that.
Not what was filed before the trial judge.
So
In
in
that-
that case,
Do everything that will facilitate writing of the judgment.
yes. Monday will be good.
Very well, Monday. Monday rekhe tha.
Also, bring your lordship notice, sir. There was an order passed by your lordship on 16th April 25, directing my lord the registrar my lord to place a
Yes,
report.
but I also wanted to see that
regarding
report.
the amount that is there.
But I also wanted to see, have a look at that.
Whichever way your lordship holds,
Yeah,
my lord, this
yeah.
would be relevant.
Whichever way.
It will mature on 14 September.
My lord.
Maturity value would be 2.13 CR. Have a look.
That could be recorded not in any of the orders, but otherwise not, we'll not get to.
Monday.
Monday, very lordship.
এটা দেখিয়ে দাও না একবার।
Next week.
Well, this was, we had called, requested not for a report about a year back. That time the response was that they had forgotten to renew, so there was no renewal for about 7-8 years.
Oh,
So interest, I think only after our letter, then they took steps in September 24, they renewed. I'm grateful.
Appeal from order old matter item number 2.
My lord, in this matter, this is a disposed of appeal. In disposed of appeal, I filed an application in 2018, which is pursuant to an order of the Supreme Court. My lord, this application is still pending. The reason for filing the application is because in a disposed of appeal, Justice Chellur and Justice Joymallo Bakshi were pleased to appoint a member of the bar as a receiver, my lord, to clear I am a clearing house agent.
who are you?
I am a clearing agent. I am my lord Sharat Chatterjee.
Sharat Chatterjee.
So my lord, I was one of the respondents, and the applicant. I was supposed my clients as clearing agent. It's they unload coal, my lord, and keep it in a port warehouse. My lord, I'm going on. The idea was to appoint the receiver. There are two contesting claimants with regard to the coal. So, my lord, Dankuni probably has gone into liquidation. Now, Dankuni and LMJ are the two contestants over the coal which is lying.
You
my
are
lord.
for Dankuni.
No, the official liquidator now. Now official liquidator, just here, my lord. From 2018, 2015, instead, my lord, 50,000 rupees was the remuneration to be paid not by me, to be paid by the two contestants just to clear my area. And my lord,
Remuneration paid to the receiver.
yes, remuneration for the purpose of clearing and getting back my go down, because up till now 3 crores rent has accrued over there, and that port land, because port will not let me go, because they are going on charging this. And my lord, from 2015 I managed to there was a purchaser who came, Justice Nishita Matre passed an order confirming sale so that it will be removed. This LMJ went up to Supreme Court in 2017, said the highest price has not been obtained. I am not concerned about highest price or highest, that's between my lord LMJ and this Dankuni to sort out. And my lord ever since and said, receiver, you do the valuation, and probably another 50,000 was directed to be paid by the contesting by the parties, didn't include me, my lord, because it's in. And from 2017, I was compelled to file this application in 2018. My lord, it is a receiver appointed by your lordships. My lord, if he cannot do it, and saying every now and then this.
Mr. Bose, we have to understand what your prayers are.
Yes, that's
We
the
have to-
application. That is why.
Hey, don't get so angry.
No, no, no. Please, I beseech your lordship.
Are you prepared to
So you fix.
address us on
I'll
this
fix you.
application?
Any day after the vacation,
No,
what
no,
he's
they-
talking about is of 2018. I have a copy of 2022 LHF.
Mr. Bose, kindly ask your advocate on record to supply a copy.
I have a copy GA1 of 2022 LHF. APOT 70 of 2020 LHF.
My lord, what is appearing, my lord?
Appearing is GA4 of 2018. প্রেয়ার গুলো আছে তোমার কাছে অ্যাপ্লিকেশন আর কিছু নেই?
No, no, my lord. The appeal, this is the, my lord,
ও
my lord,
তাহলে তো আর কি
my lord, I have filed the application in a disposed of appeal. I said that appeal is 2015.
we have understood, Mr.
Yes, yes,
Bose.
he's saying 2022. It's not, I mean, I do not know what application.
So why don't you show that application to Mr. Bose? Give him a copy. Give him a copy. Let him study it.
It's their application.
Their application.
Supriya Ranjan is,
Yeah.
please file enclosed application. Please take your instruction. That is an application filed by LMJ in some other matter,
Anyway,
2020.
come back after vacation. The papers are not available.
Papers are not,
No.
my lord, my lord, I'll tell your lordship.
What I should indicate one thing. There is one other APOT LHF that is, I think 293 is appearing LHF in the list. And there is one another APOT that is APOT 70.
Whose appeal is that?
It's an appeal of the LMJ International LHF.
That's also disposed. That is also that is also a disposed of appeal.
No, it's pending perhaps LHF.
They can near now.
APOT 70 of
My
2000.
lord,
The
I-
goods which are lying in the port
Still lying.
warehouse.
Yes.
Who is the owner of the goods?
They are two rival contestants. Dankuni says, I am the owner, because my lord, it's high sea sale, and someone says, so Justice Chellur passed an order that look here, this goods, my lord, 10,000, they are claiming interest of 10,000, about 11,000 odd is lying. So every day for 5 years, the coal, my lord, 11,000 is becoming, my lord, 100 less, because it is, and port charges are accruing.
Difficulty is a LHF. The 11,000 plus metric ton was there in the entire.
Sir, we
Dahej
will
custody
consider the difficulty.
please.
Let us find out the papers first.
Right, my lord.
Come
please.
back on the 9th or 10th of June.
My lord, the problem, I'll tell your lordship, my lord, my instructions were, if your lordship, this has been pending, somehow or the reason, every day it goes to the receiver, and receiver, my lord, because we are saying, delays the matter. Yeah, my lord, your lordship can,
Mr. Bose,
Yes.
if you make such submission,
yes.
this matter was listed at our instance.
My lord, I'm grateful
Your
that,
client
Yes.
has shown no interest in the matter.
my lord, my lord, lordship means my advocate on record. My lord, the arguing counsel has been elevated. It's come to me. I was not, my lord.
No, we are not telling you
the-
anything at
No,
all.
I am saying your lordship wants an answer from me personally. I am giving your lordship.
Come back on when? Tell us immediately after vacation.
My lord, please, as if I felt in your lordship's hand, because I am aware of this, that my advocate on record should have mentioned and all these things.
12th June, কিছু order দিচ্ছি না, 12th June.
My lord, 12 June, and I said, my lord, because if your lordship feels because of this paucity of time,
Second, if the papers are not traceable in the department, you please take down the phone number of the advocate on record. You supply a copy of the application. Huh?
along with all pleadings, the affidavit have been filed, everything.
If the papers can't be traced, you need not give now. Very well, 12th, কি বললাম? 12th June.
But if your lordships feel, no, because of subsequent, your lordship will not change the issue, I cannot go to the Supreme Court also, because as your lordship.
Let us consider, we
Yes,
don't
yes,
even know what
please,
the order is.
please, my lord, please.
Okay, come back on them.
Sorry.
Deeply obliged.
Item number 3,
My lord, I am for the official liquidator in item number 3, my lord. In pursuance of your lordship's order dated 5th May, my lord, I am, my lord, submitting the affidavit, my lord,
সর্বনাশ।
3 volumes each, my lord. Different events, my lord, what was happened, my lord, that was corroborated in this.
Who is there on the
My-
virtual platform?
My lord, if
And
you
my
remember
lord,
this,
I have also
my lord, the advocate on record had not given.
My lord, I'm the advocate on record appearing on behalf of JP Trading, my lord.
I'm now
my lord,
told
this-
that the advocate on record has informed us that she's willing to give the NOC.
Very well,
So I think today only it's going to be done.
very well, Monday.
I have sought the lady advocate, my lord, Sonchita
It's
Chakraborty.
all right, Mr. Chaudhary. There's, you come back when? When?
My lord, with your lordship, since there are new documents which are being disclosed also, if your lordship keeps it right after the vacation, my lord, we'll come back ready. Now,
Affidavit filed by the official liquidator. Lekho.
Hmm?
Affidavit filed by the official liquidator. Be kept with the records. Of the affidavit has been made over to
the erstwhile advocate on record, they'll give it to us. my lord.
the erstwhile advocate on record for the appellant. Appellant? No. Appellant.
Appellant.
Yes.
Stop.
Appellant.
Paragraph on the request made by learned advocate for the appellant. Let this matter be listed again on June 12th.
12th June. 12th June, my lord.
Deeply.
12th tarikh.
Deeply obliged, my lord.
Thank you.
Obliged, my lord.
Mr. Mukherjee, ensure that we don't have to go through those 3-4 volumes.
Very,
These
my
are
lord, very
the
short
common
point.
documents, my lord,
point
and
is-
most of the documents relied upon by my learned friend.
Very well.
Short point, this is a disclaimer application, my lord. Under the old Companies Act.
They are unauthorizedly occupied the company's property.
That has to be
This is the
disclaimed.
case of the office.
What was the section? 465? No, what was the section? 535.
535.
535.
535.
That was dismissed.
535.
535.
535.
item number 4,
This is my, lord, the issue here is a pure question of law. Whether,
unfortunately, it's a fight between brother
Yeah,
and
that's it.
sister. Father, my lord, left substantial properties, assets, businesses. Then father died, disputes arose between my lord the siblings. Then it went before the CLB regarding the mismanagement of a company. Then from CLB, they had preferred, my lord, and appeal, my lord, 10F appeal.
Why not? Why don't you try out mediation?
That was the order at the first stage.
Failed.
That has not worked.
25 lakhs, my lord, the brother was to pay to the sister. From 2012, a terms of settlement was filed.
You are Shumitra.
Yes. 2012, the terms of settlement was filed. Ultimately, my lord, my client was required to, my lord, start execution in 2024, just before, my lord.
There was a consent decree.
Yes, terms of settlement.
Terms of settlement. Terms of settlement filed where?
In, my lord, in this court.
10F
High Court,
appeal.
my lord, in 10F.
10F appeal.
It's a question of, my lord, whether the court is whether the court has jurisdiction or not. Lack of inherent jurisdiction. Because under 36, one has to file the execution application at the first court. Now, hence,
So you want to do the matter today? We are.
I was saying, Mr. What? This is the interesting question of law, their judgments. So this is.
Tell us where you want to do it.
Lord, you can dispose of the application, that the appeal will be heard out informal.
Oh, you want to file paper book?
No, it's
Small.
not required.
No, not required.
Everything is there.
Lord, you can say, can make that
There, my lord,
order.
Kindly
can
give us
make-
any day, half an hour's time. I don't think that, my lord, I will take more than, my lord, 15.
No, it will
No, we
take.
can hear you today.
Well, it will take
Mr.
some
Mitra,
time.
I think, talk to Mr. Senior Mr. Mitra.
After 11th, anything. Hello, after first week, anything.
This is just before vacation, so there are capes all around. He doesn't want to.
Yes. All are not, my lord,
Same.
all are not that lucky. Now,
You had your share, still have your share.
Yes.
my lord, immediately after the event.
Yes, give us a mutually acceptable
I
date.
was saying, if it can be
12th,
16th, I mean, 12, 13, 13, not can give 13. Right.
Impugned order. What is the impugned order?
The impugned order was stayed
In
by
execution, my
by
lord,
Justice
they had
Sen.
taken a preliminary point that my application is not maintainable. They had made an application.
I see.
That application was dismissed, and, my lord, in my execution application, order was passed.
I see. I see. This appeal is directed against a judgment and order dated February 13, 2025, whereby the appellant's application challenging the maintainability of the execution application filed by the respondent herein was dismissed. So further, an order of injunction was passed against the present appellant on the application of the present respondent. Paragraph. Mr. Obrojit Mitro, learned senior counsel representing the appellant, says that this appeal involves a pure point of law. Stop. All papers that were available before the learned single judge have been annexed to the stay petition. Stop. The appeal may be heard out. Paragraph. We shall hear out the appeal immediately after the summer vacation, treating the stay petition as an informal paper book. Stop. All formalities are dispensed with. Stop. Since the respondent is represented, notice of appeal is deemed to have been waived. Paragraph. The stay application stands disposed of. Stop. However, let the records of the stay application be retained for reference at the time of hearing of the appeal.
Well, the interim orders which were continuing, so far as I'm sorry, my lord.
Must be having the order, 29th April.
Paragraph. The
29th.
interim order that is in subsistence in this appeal shall continue till, let us say, disposal of the appeal.
We will do it,
disposal of the appeal. Stop. The order of injunction passed by the learned single judge shall also continue till disposal of the appeal. এই স্টেটাকে ডিসপোজ অফ করে দেন, কিন্তু স্টেটের ফেরত পাঠিয়ে দিও না, লাগবে আমাদের।
Grateful to
We haven't given the date.
13th.
13th. List this matter under the heading appeal from orders on May 13, 2026.
25.
আচ্ছা 25 ঠিক আছে।
Grateful to
Item number 5.
My lord, ACO number 2 is my application seeking discharge of receiver.
This is the matter in which, my lord, a stand was taken that, my lord, it has to be released, and we were opposing this.
Receiver has already been discharged, but your lordship's order dated 29th April.
No, no. Huh?
Yeah,
Hmm?
Huh? 29?
April 2025. দেখি দেখি
Eh? না না কি করে হয় এটা না না, তার আগে না না হ্যাঁ
discharged. Have you read the order?
what are you
I'm sorry, my lord, I'm seeking this.
মানে আছে
yes
Order in terms of prayer meeting.
Prayer A.
What was prayer A?
Leave to
Service,
serve.
sir.
Leave to serve.
What was prayer A?
Leave to serve.
Lord. Leave to
Leave to
serve.
serve.
Short.
Somebody was objecting to our hearing the matter. Who is that?
Because
My
your
lord,
lordship
on
has asked
the
for in
last
writing, not
occasion,
that.
my lord, we said that, in fact, Mr. Sinha, my lord, was, my lord, pleased to point out that, my lord, they should either file an application or, my lord, come with an affidavit.
একটু চেঞ্জ করে দে কি জাস্ট চেঞ্জ অফ রিসিভার মেরিটে তো কিছু সাজেস্ট আ নেম
অনিল গুপ্ত ভালো
হ্যাঁ অনিল
অনিল গুপ্ত অনিল গুপ্ত অনিল
অনিল গুপ্ত
অ্যাপ্লিকেশনটা দাও
কত টাকা আছে
এই তো একটা 40 লাখ সামথিং একটা
মাস খেতে রাখি
একটা এই যে 21 লাখ আর আরেকটা না দিস ইজ ওয়ান ব্যাংক অ্যাকাউন্ট স্ট্যান্ডার্ড চার্টার্ড আর আরেকটা এটা 1460 only
টোটাল
হ্যাঁ এই দুটোই তো আছে এইটা একটা আর এইটা একটা 21 লাখ আপনারা সাজেস্ট করুন আমাদের কোনো ইয়ে নেই ভিতরটা মাত্র 5টি দিল হ্যাঁ আছে তো
He was appointed as receiver by order dated 24th August 87,
yes
as would appear from prayer B.
yes
Where is that order?
my lord that order is starts at page 20 I'll just page 18
18 is a different date.
page 18 operative part is
Sir, page 18. Huh? That's 26 July.
yes
What is? Look at prayer B.
no but he was appointed by this order my lord
Sir, kindly look at prayer B. Clear our confusion.
এইটাই August 1987 no I think that has been a mistake because এইখানে আমি দেখেছি
ওটা ভুল দিয়েছে It seems to be 26 July.
My lord, I think the prayer portion there is a typographical error because the actual order should be 26 July 1988, which is at page 18. My lord will find it at page 29.
দুজনের নাম আছে অমল দত্ত and
Page 29A.
yes, have you agreed on a name?
I was suggesting Mr. Anil Gupta will have or Mr. Shorbendu Ghosh. Yes, yes, absolutely.
On Sharnendu Ghosh? on the same terms and conditions? Just the change of personnel?
Yes.
We need not address the merits at all?
No, not at all. The only thing, my lord, the
The handover.
my lord, should be directed to handover, my lord, and whatever remuneration your lordship expect.
What was the remuneration
My
fixed
lord,
for
the
him?
remuneration was fixed in 88 at 1700 GMs per month. So that is what he has last received in March 2025.
So one time,
Yes.
If-
Final, at the
Final,
end of
huh?
discharge.
Yes, if I can. 6,800 for 4 months together.
Mr. Mitro, Mr. Sinha, please advise, because we don't know the magnitude of the matter. How much?
Not, to be very candid, my lord, neither do I, my lord.
He holds about 25 lakhs, my lord. That's
No, 21 lakhs in one bank account
Hmm.
and another 40,000 odd in another
22
bank account.
So
22 lakhs.
one time, how much should it be?
That we leave to my lords.
One? No.
Yes, for the time being, my lord, kindly.
No, this is the final because he is being discharged.
Oh, I see.
okay. In another matter, my lord, 3 lakhs was paid, my lord, for him.
Relax. But then, how much was he holding?
Now, about 50 lakhs.
If that be so, 1.5. 1.5. This application has been taken out by, he is the sole receiver at the moment.
Yes, he is the sole receiver. Initially, 2 people were appointed. He is
By-
continuing as the sole receiver.
The sole receiver, comma, Mr. Deepak Deb, comma, Bharat Law, comma, for being discharged as receiver, stop. Stop. The petitioner was appointed as joint receiver by an order dated July 26, 1988. Stop. Paragraph. The present application has been taken out by the petitioner, saying that he is suffering from various ailments. Stop. Also, comma, he because of his age, comma, he is not in a position to discharge duties as a receiver any further. Paragraph.
Age and health.
The
Age and health, but he's suffering from cancer. my lord.
health, I've said, various ailments.
But I only heard the age. part.
Various ailments, we have said. Paragraph, we have seen the petition, stop. We are inclined to relieve the learned receiver, stop. At the suggestion made by learned advocates for the parties, comma, we appoint Mr. Shornendu Ghosh, comma, learned, now he's senior advocate, comma, as receiver in the place and stead of Mr. Deepak Deb, comma, who hereby stands discharged. Stop. The appointment of Mr. Ghosh will be on the same terms and conditions on which Mr. Deb had been appointed. Stop. Paragraph, Mr. Deb shall receive a final remuneration of rupees 1.5 lakh, which he shall be entitled to deduct from the money that he is holding in bank accounts. Stop. He shall hand over all relevant papers and hand over charge in general to the incoming receiver. That's all.
The concerned banks, my lord, have to act on the basis of this order.
Stop. Paragraph, all parties and the concerned banks shall act on a server copy of this order. A GA whatever is disposed of. ACO2 naki dekhe nahi hoga.
One time, 1 lakh ko lo.
Initial remuneration for
Na,
Mr.
na, receiver ke diye.
Acha. And then 1700 GMs per month. After that,
Same terms.
same terms.
Much.
Item number 6.
Shall we increase that? No, 1700. No. There's not much money in the account.
Still, my lord,
Later you can consider.
Item number 6.
একটা দুটো হলো বাবা।
My lord, I appear in support of this application. My lord,
In this matter, my lord,
my lord, very unfortunate matter, my lord. This is an application, my lord, seeking leave to draw up a decree of 1997. Notwithstanding, my lord, two orders by the division bench, my lord, each time, my lord, objection by the department and last, my lord, by the learned master has been given. My lord, before lordship takes it up, my lord, at that point of time,
on submission, my lord. My lord, in this matter, Mr. Omoleshwar is appearing for the respondent number 2, my lord. My lord, on behalf of him, my lord, I am praying for adjournment, my lord.
well, this is not much of an adversarial proceeding. Well, my lord, yes, my lord. As of now, my lord, if lordships, my lord, pass an order in terms of prayer H,
এই দাও এটা।
and my lord, let it be there before your
We are not
lordship.
disposing of the application. Don't
Prayer
look
H,
so
and
worried.
I shall do the matter on Monday. I shall do the matter on
Mr. Roy
Monday.
will be there on Monday.
Your lordship kindly take it after vacation, my lord.
Why? Tell us, give us a good reason.
My lord, Mr. Roy has some difficulties, my lord. He is in Jalpaiguri, my lord.
No, that is that is no reason. Circuit মারছে. Is the circuit is on এখন নাকি circuit?
Up to 23rd, my lord, sir.
How can he oppose this? Let him appear virtually. এই দেখি পিটিশনটা দাও কি প্রেয়ার এইজ বলছে।
My lord, your lordship kindly fixed any date in the next week, my lord.
We are keeping it. Let us see what prayer age is first. Mr. Chaudhary is saying
But so far as prayers, my lord, D to F are concerned, my lord, D to G, that can be passed today. That is, my lord, amendment recording the death. And my lord, prayer H is, my lord, this requisition number, the my lord, master's record be produced before your lordship.
D2G is
My lord, I am not on record, my lord. My lord, your lordship kindly, whatever order your lordship,
sir. D2G is formal order.
pass it in the next week, my lord. My humble submission,
Very well.
because my lord, I
Well, H will pass H today.
Yes, my lord.
And
Very well. Very
D2G will
well.
pass on
Very
Monday.
well.
H number
Records টা শুধু আসবে ভাই, তাদের কোনো আপত্তি
This application has been taken out by the decree holder.
Yes, my lord. By the decree holder.
By the decree holder for drawing up a judgment and decree dated May 22, 1997, passed by a coordinate bench in APO number 504 of 1992. Stop. Paragraph. We are surprised that a decree which was passed about 28 years ago, comma, is yet to be drawn up and completed. Paragraph. Let there be, as of now, let there be an order in terms of prayer H of the application which reads as follows. বলে H-টাকে set out করে দেবে, হ্যাঁ, colon দিয়ে. Page 39. Paragraph. Insofar as the other prayers are concerned, comma, adjournment is sought for on behalf of the respondent number 2. Paragraph. List this matter once again. Next week, original side, non-commercial. আজকে হচ্ছে তাহলে সোমবার হচ্ছে কমার্শিয়াল, তার মানে বুধবার। সেই বলছি কালকে কমার্শিয়াল ফার্স্ট, অরিজিনাল সাইডে কমার্শিয়াল ফার্স্ট, তাহলে মানডেতে অরিজিনাল সাইডে নন কমার্শিয়াল। Monday or Wednesday, Mr. Chaudhary?
Any day convenient to your lordship.
Wednesday. She's saying Wednesday করে দাও, list the matter.
But is it my lord's pleasure to make it part-heard? I'll say the reason why. My lord, my lord, this has been released by my lord at least 4 to 5 benches.
Why? Let us see, ওরে বাবা, দেখি তো নামগুলো দেখ।
Because my lord, Many people had appeared in the matter, my lord. This is Lordship recalls, my lord, the decree was passed by when Justice Pal was adorning the benches. So, my lord, in course of time,
This Kusum Agarwal is of Khaitan Company.
no.
Hmm?
Nothing to do with Khaitan Company.
Nothing to do with Khaitan
Nothing.
Company. No, I don't think I ever appeared. At least doesn't ring a bell.
No, my lord, my instructing advocate is sure about this, that lordships have not appeared.
We are happy to see Ms. Ghosh in a non-criminal court. No, it will look very funny.
Very well. Yes, my lord, under the present circumstances, yes.
Sure.
Very well.
শোনো এই তাহলে মাস্টারের কাছে অর্ডারটা দিতে হবে, কারণ মাস্টারের উপর ডিরেকশন। কে দেবে কিছু বলতে হবে অর্ডারে?
Same order করে দিন।
The court officer is directed to immediately communicate this order to the learned master.
In the next matter, similar order can be passed, only the APO number will be different. APO number
একই
will
অর্ডার রেখো।
It's a common judgment, my lord, so.
Prayer each, same prayer each.
ওটা prayer H ই আছে তো?
চেক করে
H দেখে নাও। Same বলে দিলে তো। Deeply হবে।
check it up prayer each.
এই তো?
Item number 8.
Eight. Reciprocal.
Yes.
Tell us.
Kindly take it off after this.
After. You are for the appellant. You are for the respondent.
I am for the respondent. The difficulty that I am under.
But you have a counsel's discretion to exercise. Be reasonable. You are 5 days away from summer vacation. We have no problem. Let us make it clear. We can hear even on a Saturday.
I showed also Mr. Mitra the pressure,
You two, both of you decide and tell us. Don't put us in difficulty.
Only one prayer.
Yes.
Kindly fixes any date and time. Any day.
Date, yes, no time. Not for the time. It's at the top, appearing at the top, Mr. Dashgupta. Why do you want a time? Today, hey, give us the date. Give us the date. No. Time nahi. On the request made by learned senior advocate appearing for the appellants, let this matter stand adjourned and be listed again on blank, retaining its position. 16th? 12th. June 12th. 9th we are reopening. You want it on the 8th?
Lordship, any day after 12th, my lord.
Sorry?
Any day after 12th if Mr.
Who are you for?
Object, Mr. Mitra is leading me, my lord.
He's leading you. Tell us, Mr. Sharma, when?
Any day after 12th. No, on 11th and 12th, I will not be here. my lord.
Fix it as per convenience.
When will 14th?
Yes.
May it retain its position. That my lord can.
Retaining his position. And 14th is a Saturday, all right.
Oh, I'm so sorry.
16th করে দাও। চলো same order in
12.
8 থেকে 12 একই অর্ডার করবে, কিন্তু আলাদা করে করবে। Same.
Item number 13.
Well, I do appear for the appellants in this matter. On the last occasion, I indicated that one of the respondents have expired, two of the respondents have expired, and a substitution application has to be made. We have made it ready, my lord. We will file it, my lord, within the coming week, my lord. Let this matter appear, my lord, after post-vacation, my lord. Within that time, the application.
Their attempt to file the written statement after a delay of 40 years
Yes,
has been foiled by them.
That's a merit of the case, my lord, with prejudice.
Against that, they have come up in appeal.
Yes. The learned single judge has declined.
Has been equally despicable, Your Lordship.
All right, madam, two respondents passed away. Is that correct?
Lordship.
Then they have to file a substitution. Merits we are not considering today.
And I will satisfy your lordship that I was justified.
You may have an uphill task, 40 years delay, if what she is saying is correct.
40 years delay, but from the filing of the suit in the 80s until today, the suit is still at the inception stage. Nothing has been. Records can be called for.
That is enough for today. Learned advocate for the appellants says that two respondents in this appeal have passed away. Stop. He says that the appellants are in the process of filing a substitution application. Stop. Paragraph as requested by learned advocate for the appellants, comma. List this matter once again on June 11, comma 2012, comma 11, comma 2025. Stop. If in the meantime any 11. If in the meantime any application is filed, comma, the same shall be listed along with this appeal.
Lordship, my only humble request today is let this be a peremptory direction. Because
Let this be?
peremptory direction, Lordship, because
We had not given any direction earlier. So why do you say peremptory?
the matter came up on the 1st of May.
Maybe, but we did not. আমরা কি কোনো order আছে আমাদের?
There was an order. There was an order. We sought for leave.
Oh, আরে তারপরে লিখে দাও ডেটটা কত?
1st May 2025, Your Lordship.
1st May. We notice that by an order dated May 1, 2025, we had adjourned this matter on the prayer made on behalf of the appellants to enable them to file an appropriate application. Stop. Learned advocate for the respondents says that the appellants are indulging in dilatory tactics. Stop. Paragraph. If the appellants do not file necessary application before the adjourned date, comma, consequences will follow. Happy?
Item number 14.
I'm my lord for the appellants. My lord, it's my lord a case of suo motu transfer of winding up proceeding, my lord, to the NCLT.
ওইটার সঙ্গে জেসপের সঙ্গে করে দাও। কবে আছে? রোজই আছে। শোনো, ট্যাগ না করে ঠিক তার পরে দিয়ে দাও। ট্যাগ ব্যাক করো না, ঝামেলা হয়। পরপর দিয়ে দেবে।
It'll appear separately.
Separately, immediately after that.
Item number 15.
I appear for the appellant. We have served the bank and the inventory is complete. If Lordship sees my lord's last order of 23rd April 2025,
Order it to the
And the report is special of bank manager needs time. So can you went for also hearing of chicken
well, the bank manager was the special officer appointed who was required to complete the inventory But I'm told that bank requires some more time to complete.
No, only to give the
Oh,
report.
he only requires some more time to file the report before your lordship.
Who?
The manager of the Indian bank.
Very well. How much time? You are appearing for whom?
For the respondent.
Rajiv Jindal.
My lordship will kindly keep it after vacation.
After vacation?
After vacation. In the meantime, I think.
Inventory is complete.
Yes, inventory is complete.
Aye, issue. Read order dated April 23, 2025. Paragraph. Learned advocate for the appellant says that inventory of the locker
Yes, locker.
of the concerned locker has been completed. Stop. However, the manager of Indian Bank, Alipur branch has sought a little more time to file his report as he was directed to do by our order dated April 23, 2025. Paragraph on the suggestion of learned advocates for the parties, let this matter be listed again on June 13, June 13.
Any day before that, because
9 June we reopen.
Any day.
13 June?
13 June.
Friday the 13th?
13th. Friday the 13th.
Horror. 13, June 13.
We have communicated all the orders. May I file the affidavit of service?
Paragraph affidavit of service filed on behalf of the appellant be kept with the records.
Grateful.
Item number 16. Item number 18.
But here, my lord, I also have a connected appeal, which has not been listed. If your lordship could list that, my lord, appeal along with this one. When it's from the same decree, plaint has been directed to be returned.
My lord, I do not know about their appeal, my lord. Kindly take, my lord, the learned judge, my lord, factually has held everything in my favor. The plaint has been returned only on the ground that it is a commercial dispute and plaint is liable to be returned. So the question.
Mewawala.
Huh?
Mewawala.
My lord, the question is a dispute arising out of family arrangement, which also deals which also deals with business. Whether
Mr. Bachawat is appearing? No.
Yes. So the question is, my lord, the document in question out of which the dispute arises is a family partition. Under that, my lord, various shops were given to various brothers. And my lord, we were enjoying an injunction order because the dispute was arising out of a family partition. In the interlocutory application, my lord, one of the points taken was that it should be adjudicated by the commercial division. And my lord, on merits, my lord, everything the learned judge was pleased to hold entirety in my favor. But my lord, on this point, my lord, it has been held that it's a commercial dispute.
The mark was Sindharam Sanvarmal. No,
my lord, mark is a separate issue. I'll come to that later.
No. The agreement was that beyond 1 kilometer with a prefix or suffix, anybody can use it.
My lord, the agreement was that, my lord, since, my lord, this was the third or the fourth generation when the family arrangement took place. Lord, this is the business, family business was of dry fruits. Now the dry fruit business was, my lord, made popular under the mark of Sindharam Savarmal. Now the gentleman and subsequently the 5 sons, my lord, they also started opening up, my lord. It's a well-known brand so far as Calcutta is concerned. The sum and substance of the settlement was that each branch will use the mark with a prefix or suffix of that branch. For instance, if I am in branch A, I will use A Sindharam Savarmal or Sindharam Savarmal A. Somebody is B, he will use B Sindharam Savarmal or Sindharam Savarmal B. Accordingly, my lord, this was done. One of the conditions was that wherever in Calcutta you are, all over India you carry on business, but where there is a shop originally existing, you can't set up another shop within 1 kilometer radius.
Clause 3 or C, what is 3? Clause 3.
Lord.
Mr. Chaudhary, let us list his appeal also. all the points were not decided in your client's favor, perhaps. For example, your client was wanting to enforce the negative covenant of this. Within 1 kilometer, it can't be done. The finding, if I remember correctly, is that you have not discharged your obligation under the arrangement, and therefore under Section 42 of the Specific Relief Act, your client claimed
My
to
lord,
enforce.
I'll come.
Anyway, we'll hear.
Come to that, my
Yes.
lord. That is.
So for the timing, give your appeal number. When? Tell us. Tomorrow? No.
Yes.
Tomorrow?
my lord.
Mr. Bachawat is available tomorrow?
Perhaps, but I'll have to.
But then keep it on Monday, my lord. Unnecessary কেন করছো?
Monday. রেখে দাও এটার পরে ওই যেটা দিচ্ছে appeal নাম্বারটা নাও। নাম্বারটা যায় না দিয়ে যাবে।
লাগবে না এই কোর্টে পেপার বুক লাগবে এটা দাও পে নিয়ে এখন হবে কি তোমার তো সুটই নেই ভাই
Item number 19.
My lord, this is my appeal, my lord. My lord, the appeal is from an order by which, my lord, my application for re-examination of the plaintiff's only witness and, my lord, for leave to disclose additional documents, my lord, was dismissed. My lord, that result of this order is, my lord, I am unable to adduce any further evidence.
What is the purpose of re-examination?
My lord,
to clarify any ambiguity
yes,
in cross-examination.
Yes, my lord.
Right.
To explain matters which has been
It is
referred
not
to.
to fill up lacunae,
my lord,
in your examination in chief.
No, yes, absolutely, my lord.
Right.
Absolutely.
The learned judge has held that the questions that you have referred to,
my lord,
which are ambiguous, the answers are not ambiguous at all. No, yes, specific answers. No ambiguity. So this was an effort on your client's part to fill up lacunae, which is not permissible and therefore dismissed.
My lord.
We have done our homework.
Yes, my lord, absolutely. My only thing that I would like to say, my lord, if my lord goes through the deposition and the ambiguities that I have pointed out in my application, my lord will see that it was no lacuna in my examination in chief. Certain matters cropped up in the cross-examination. Certain documents were specifically asked for from the witness, who said initially that they were in the judge's brief. And then he said the document is there, it is not there in the judge's brief. Now, may I just indicate, my lord, there was a second issue also in this matter. That is, my lord, one of the issues in the suit was what is the valuation of the suit property. Now, my lord, I can show from the documents on record that a deed of conveyance was executed in respect of an identical flat in the same building, but that was executed after the examination in chief of my client was concluded. My client was a party to that deed, my lord. That deed could not have been brought in at the time of the examination in chief, because admittedly the deed did not exist.
You wanted a recall under Order 18, Rule 17.
My lord, I'll just indicate, my lord, the moment the cross-examination concluded, I made a submission that I want to re-examine the witness. The learned trial court was of the opinion that I take out a formal application. So my application was, my lord, for re-examination under 138, coupled with, my lord, leave to
138 Evidence Act.
Of the Evidence Act, my lord, coupled with a prayer, my lord, for leave to disclose further documents which I had already served upon the other side, since I want to rely on certain subsequent documents which did not exist at the time when, my lord, one of the documents being which did not exist at the time when the examination in chief was, my lord, made.
Order 18, Rule 17
is, my lord,
is
recall.
the court's discretion.
Absolutely. my
If
lord.
the court thinks it is necessary to recall a witness to clear any ambiguity, then the court can at all stage.
My lord.
Does that give you the right?
No, my lord. It does not. It is absolutely the discretion of the court, my lord.
Totally.
Now, only
Court
thing.
felt that it was not necessary.
Now, only thing, my lord, I have specifically, my application had been drafted in such a manner that it was for clarification of issues which cropped up during cross-examination. So even before the trial court, I had submitted that my application is within the scope of section 138, my lord, because it is not like after the closure of my witnesses' oral evidence, my lord, after 6 months or so I had applied. I had immediately asked.
Evidence একটা দাও।
Evidence একটা কোথায়?
কোর্ট করেছে ও। আচ্ছা দরকার নেই। Correct.
ওকে দাঁড়া দিচ্ছ নিজে তো করো না কিছু এখানে গ্রুপ রেডি থাকবে My lords have gone through section 138. My lord will see that the re-examination shall be directed to explanation of matters referred to in cross-examination. And if new matter is by permission of the court introduced in re-examination, the adverse party may further cross-examine upon that matter. Now, my lord, here it shows that even new matters may be introduced, my lord, but subject to leave of this court. Now, may I only indicate from my application and the deposition, my lord, as to what clarification or, my lord, what explanation I was seeking to give through re-examination, my lord, and what are the documents that I had disclosed and then why it was disclosed. My lord, whenever a new document is introduced, my lord, the respondents or the other side, my lord, has the right of cross-examination. So, my lord, the equities are balanced. It's not like I am gaining any unfair advantage by re-examining the witness. If my lord kindly comes to my application once. If my lord kindly comes to my application before the learned trial court once, which begins at page 673, volume 5, my lord. My lord, before I place parts of this application, may I just give a background of the suit, my lord? May I just give a background of the suit? There was an earlier suit between the parties, my lord, for specific performance of a contract for sale of certain flats in a building.
Mr. Mukherjee, please understand, we are not in season of the suit. We are not hearing the suit. We are not interested in the
Very well, my lord. I will not go to the background
learned
of the
judge who is in season of the suit
My lord.
is of the opinion no re-examination is necessary.
May
He is going to decide the suit.
Absolutely. I was just giving the background. I won't, my lord. My lord will kindly come to my lord page number 686 of my application. I'll only place portions of the application and the deposition.
GD. Yes.
Yes. Internal page 14 of that application, running page 686, my lord. Kindly seize, my lord. Paragraph number 38 at internal page 14.
Yes.
After the issues were framed, the examination in chief of the plaintiff's witness, being the plaintiff himself, such and such, commenced on December 8, 2022 and concluded on August 7, 2023. Malas, these dates are important, why I'll indicate later on. The cross-examination of Sushil Kumar Agarwal, such and such, commenced and concluded on September 5, 2024. In course of the cross-examination of the plaintiff, certain pertinent facts emerged that required further clarification to ensure comprehensive understanding of the matter. Thereafter, my lord, in the table, my lord, I had indicated what were the questions and what was the, my lord, documents which were raised and what was the clarification required. I will place these questions, my lord. Now, my lord kindly turns the page over and my lord kindly takes paragraph 45, my lord, at page 687. With regard to the deed of conveyance dated May 20, 2024, kindly notes the date, my lord, executed by and between the plaintiff and one Mr. Probir Kumar Sarkar, it is humbly submitted during its that due to its unavailability at the time of disclosure of documents and examination in chief of the plaintiff was precluded from disclosing the same on earlier occasions. So, my lord, this deed was executed on 20th, it's a registered deed, my lord, it was executed on 20th of May 2024. Whereas, my lord, will see on the last, in the page before that, the examination in chief was concluded on August 7, 2023. So, we could not have brought this document on record on a prior occasion. Why we want to rely on this document? It is because the document would show what would be the market value of the property within. Now, my lord, issues number 3 and 4 I will show, my lord, is with regard to the specific, my lord, issue, what is the valuation of the property. My lord, this is a crucial piece of evidence. Now, my lord, will kindly now, these are the only two aspects in which, my lord, one for clarification. Now, my lord, will kindly see the...
Where are these questions and answers?
Yes, my lord. Kindly sees the deposition which begins at page 619, same volume, my lord, volume 5 only. Kindly sees, my lord, will first see question number 115 at page 642. So, my lord, certain properties were amalgamated together. This is in cross-examination 115. Have you disclosed the amalgamation certificate you are talking about? The document was given in the judge's brief of document. 116. Can you identify the document from the judge's brief of documents? It is on page 74 of the plaintiff's judge's brief of documents. Are you sure this is the document? Yes. I am suggesting to you that page 74 of the judge's brief of documents being exhibit 17 is a mutation certificate and not an amalgamation order. What do you say? Yes, it is a mutation order. Is there any other document to substantiate your assertion that the premises number such and such were amalgamated into premises number 344 Canal Street, Kolkata? It is not in this judge's brief of documents, but I can show this. And the witness was never called on. No further questions were asked to show this document that the witness had volunteered. He had specifically volunteered, I can show this, but there were no further questions asked. Now, the additional document that I had disclosed, my lord, is the document which will show that these three premises, my lord, were amalgamated together into 344 Canal Street. So, my lord, if a question was asked,
why did you not re-examine him immediately?
My lord, that was my that was my prayer, my lord. My learned other side was there. When the cross-examination was concluded, I immediately made a prayer. In fact, I had disclosed the documents even before the cross-examination was concluded that kindly allow me to re-examine. That is when the learned trial court was of the view that I should take out a formal application. My lord, so my lord, I took out a formal application. My learned friend was there, my lord, all along. He will not contradict me when I make this submission, my lord. I took out that application, my lord, affidavits were exchanged, and then I did it immediately, my lord. Even the additional documents that I intended to disclose, I had disclosed it prior to conclusion of the cross-examination, my lord. Now, if my lord kindly takes the next question at page 140, at page 647, my lord. Question number 143. Is it correct that sanction plan dated 25th September 1995 bearing number such and such was a provisional sanction and was subject to NOC from the airport? No. shown a sanction plan relied upon by you, which clearly reads sanction is provisional NOC from airport authority is to be obtained before construction. You still maintain your answer to my question put to you. No, there was no rule plan certificate issued by South Damdam municipality. Now, my lord, here, my lord, I must say that the witness, my lord, probably, my lord, didn't give the answer that was required because there were sanctions. Sanction was subject to no objection by Airport Authority of India, and he had those documents, but it was not disclosed. Those were the documents I had disclosed that even the Airport Authority of India had given their no objection for sanction. And my lord, the third question, my lord, we'll see at page 651. My lord, question numbers 158 to 160. This letter that you have just identified is only a reply to the letter dated 14 September 2020. Did you issue any other letter in reply to the other two notices dated 13 March 2020 and 2nd March 2020? Yes, I have replied on the other two letters. Have you disclosed the reply to the other two letters? Yes. On the next date, kindly come and indicate where are the replies to the aforesaid two letters? Yes. But my lord, will see the next page. No question was asked on follow-up of question number 160. Question number 160 said, on the next date, kindly come and indicate where the replies are. Now, my lord, question number 161, my lord, will see that there was no follow-up question. The reply was, my lord, subsequently disclosed as an additional disclosure. There was a reply given, my lord. So, my lord, original genuine documents are there with me. Now, may I just show, my lord, the documents I had.
Yes, what else?
Yes. My lord will kindly see the documents I had disclosed that my lord will find at in volume number 3, my lord, page 422.
Mr. Mukherjee, again you are missing the point. A learned judge is about to decide the suit.
My lord.
His lordship is of the view these are not necessary. This re-examination is not necessary. We are not deciding the suit. If you lose and come before us or before a division bench, the division bench will then form an opinion. Why should we strain our brain?
My lord, only, my lord, for the purpose that if I am not
purely discretionary and a well-reasoned order. No.
My lord, may I just show one part of the order, my lord, which says that additional disclosure and re-examination cannot be made in the same breath. Now, my lord will see that by the impugned order, I have been given liberty to take out an application for disclosure of additional documents. My lord was of the view that these two things should not have been done together. Today, my lord, if I follow that liberty and my lord, I take out an application for disclosure of additional documents, I have no witness. Nobody will be able to come and prove it, my lord. Because plaintiff is the only person who was a developer, my lord. And my lord, there is no other person. And if I bring my lord, that would not be right because not concerned with the documents. So, my lord, even if the liberty was given, my lord, so far as the document which I had executed, which took place after the examination in chief was over, my lord, why should I not be allowed to rely on a document which did not exist when the witness was being, my lord, examined in chief and cross-examined? There cannot be a question of filling up of lacuna when the document did not exist when the oral evidence was being taken on record. Kindly takes that document, my lord, which begins at volume 3, my lord, at page 422.
Where is the application you showed us?
Yes, my lord. That application is at volume 5, my lord, begins at page number 673. And my lord, in paragraph number 45 at page 687, I had specifically stated that the deed of conveyance did not exist when the parties was being examined, my lord. Just before closure of cross-examination, my lord, the deed was registered. I completely understand, my lord, that the trial court had, my lord, exercised discretion, my lord. But so far as, my lord, this document is concerned, which did not exist, my lord, I would humbly submit that, my lord, the trial court fell in error in holding that this was for covering up of lacuna. When the document did not exist, my lord, how could I have brought it into, my lord, during evidence? Kindly sees paragraph 45 at page 687, my lord. And, my lord, it is not like the defendants don't have, if I am putting in further documents, my lord, they have their fullest right of cross-examination. And, my lord, will kindly see the language of section 138. My lord, I would humbly submit that it is perhaps not totally up to the discretion of the court. Order 18, Rule 17, yes, my lord, I can understand that there is completely, but this is not a case of recall, my lord, as I humbly submitted that this was under section 138. I have given the dates when the chief began and when it closed, and when the deed of conveyance at paragraph 45 was executed. At least till that extent, if my lord kindly permits me. If I had a second witness, my lord, I would not be facing these problems.
Mr. Mukherjee, we can do this. Listen to us. We are not interfering with the order, but we'll note that the learned judge has observed that there is a procedure for disclosing additional documents, and you may make a prayer for recall of PW1 in that application itself to prove the documents that you propose to disclose, and the learned judge will consider that prayer in accordance with law.
Very well, my lord. This order, my lord, will not stand in the way.
This order will not stand in the way.
I am grateful. I will be. I'm will be grateful.
Go and make your submission there. We are not interfering with this order.
If a liberty is given to make a prayer for recall.
No, we are not giving. Yes, a liberty. Yes.
Then, my lord, my difficulty here would be, my lord, then practically the order would be set aside, my lord. My lord, kindly hears me, my lord, on these questions, my lord.
Yes.
And then, my lord, will decide, my lord. My lord, the learned single judge, my lord, proceeded on the premise. The application was made saying that there are certain ambiguities in the question which was put to the witness in the course of cross-examination. And my learned friend, my lord, has, my lord, at page 673 is the application. Kindly takes the application, my lord, and put at page 686, there is a table at paragraph 41, my lord.
Yes, we saw that.
My lord has seen that. So 4 issues were there. 4 set of questions have been, my lord, shown to be which have ambiguity, my lord. Now, my lord, the questions, my lord, first set of questions, my lord, pertain to the amalgamation of property. The witness has relied on a document which in cross-examination, I asked the witness whether there is any document to show the properties were amalgamated. He said, yes, there is. And I showed him the document on which he relied. It was a mutation certificate. He said, this is the document. I moved on. I gave a suggestion that this is not that document. And I moved on to the next set of questions. The learned court below found there is no ambiguity in this question, Millard. Kindly takes question 115 to 120 at page 642.
Tell us one thing, whatever it be.
Yes.
Now, Mr. Singh, is he precluded in law from seeking leave to disclose and rely upon a document which came into existence after PW1 was discharged? Is he precluded in law?
Absolutely not.
Right. Then he can make a prayer today for disclosure of such document in the suit. The learned judge has observed that also. How will he prove that document?
Let him bring a witness, my lord. Why under the garb of re-examination, my lord?
No, on recall, has to be recalled then.
A new witness can come and prove those documents.
If only the PW1 can prove it, then PW1 has to come.
He's a party to the document,
Yes,
my lord.
He's a party to the document.
So only so far as because that document is concerned. But
Yes.
my lord, Kali takes these 4 questions, my lord, under the garb of that document, my lord. Are these questions related to that? It is
Therefore,
not.
We are not interfering with this order.
Only if,
So he
if
will
my
not
lord,
be. He will not be entitled to re-examine on these
on
questions.
these questions. Yes, I have no difficulty. But only with regard to that document, which has come
That's what
subsequently,
we
I
are
have no
saying.
difficulty. But under the garb of that document, my lord, if the witness comes back, and
That you have to object and see that the learned judge doesn't allow that. We'll not be there to help you there.
if my lord clarifies that the questions set out in paragraph 41 have got nothing to do with this examination, I have no difficulty. Because I have made inroads to the witness in course of my cross-examination. That cannot be said at not, my lord, by way of recalling.
Correct. তাতে তো credibility affect করে। This appeal is directed against a judgment and order dated February 27, 2025, whereby an application judgment order dated February 27, 2025, whereby the appellant the appellant's application being GA5 of GA5 of 2024 was dismissed by a learned judge of this court. Paragraph. The appellant is the plaintiff in what suit? Eviction suit?
A suit for specific performance.
Plaintiff in a suit for specific performance
of an agreement to sell an immovable property.
Specific performance of an agreement relating to an immovable property. Stop. The respondents herein are defendants in the suit. Paragraph. The plaintiff examined himself as PW1 and was discharged on or about. You gave the dates in your application.
Yes, my lord. The cross-examination was
September 5.
September 5.
September 5, 2024. After being cross-examined. Stop. Paragraph. The present application was taken out soon thereafter, on September 30, 2024 for recall of PW1 for being re-examined. Stop. The learned judge. Now, in the application, it was stated that it was stated that the answers to certain questions put to the PW1 in cross-examination, need clarification. Stop. Therefore, re-examination of PW1 is necessary. Stop. Paragraph. The learned judge, in essence, held that there was no ambiguity in the answers to the concerned questions put to PW1 Stop. Neither was it necessary to recall PW1 for further examination in exercise of power under Order 18, Rule 17, CPC, nor is re-examination of PW1 necessary as contemplated in Section 138 of the Evidence Act. Stop. Accordingly, the plaintiff's application was dismissed. Stop. Being aggrieved, the plaintiff is before us by way of this appeal. Paragraph. Learned Mr. Mukherjee, learned advocate appearing for the appellant oblique plaintiff, says that it is of crucial importance that the plaintiff is allowed to disclose and rely upon a document dated,
My lord,
20th May
20th May 2024.
2024.
May 20, 2024.
My lord.
May 20, 2024. Which came into existence after examination in chief of the plaintiff was over.
On August 7, 2023.
On August 7, 2023. Stop. To prove that document, it is necessary to further examine the plaintiff on recall, as the plaintiff is a party to that document. Stop. That document is extremely relevant for the purpose of coming to a decision regarding the valuation of the suit property.
My lord, which is an issue in the suit.
Which is a specific issue in the suit. Stop. Paragraph. Mr. Singh, learned advocate appearing for the respondents oblique defendants, says that in the garb of, says that the questions referred to by the plaintiff in his application before the learned single judge, the answers whereto, according to the plaintiff, are ambiguous, are in fact not so. Stop. The answers are quite clear. Stop. The learned judge rightly held that it is not necessary either to recall PW1 for further examination or to re-examine him in terms of Section 138 of the Evidence Act. Stop. He submits that the order under appeal does not call for any interference. Stop. Paragraph. To our query as to whether or not the plaintiff is entitled to rely on a document which has come into existence after the plaintiff's examination in chief was concluded, Mr. Singh fairly submitted that the plaintiff cannot be precluded from doing so. Stop. However, doing so, following due process of law. Stop. However, under garb of the same, the plaintiff cannot again address the issues covered by the questions and answers referred to by the plaintiff in his application before the learned single judge. Paragraph. Having heard learned counsel for the parties, we are of the view that the plaintiff should be permitted to rely on the document referred to above. Stop. For that purpose, he may make an appropriate application before the learned single judge. Stop. We may note that learned single judge in the impugned judgment and order has also observed that there is a procedure for relying on additional documents. Stop. In the said application, the plaintiff may make a prayer for being permitted to prove the said document in accordance with law, if necessary, by recalling PW1. Stop. However, we clarify that the matters covered by the questions and answers indicated in the plaintiff's application before the learned single judge shall not be raked up again if PW1 is examined on recall. Paragraph. With the aforesaid observations, the appeal and the connected application stand disposed of.
Extremely grateful to my lord.
Number. আচ্ছা আমি দেখিয়ে দিচ্ছি কোথায় কি ভুলে গেছি তো কোথায় বলেছি prove the rely on কেটে prove will come back. Yes,
Lord, can I do it on Monday, my lord?
you can.
Because I was there yesterday. A matter got fixed, my lord. I was in court for
You can do it Monday week also.
No, Monday week is a holiday.
Yes, so what holidays?
Very well.
Huh?
If Lordship my lord permits the professional difficulty.
Monday.
Monday. I don't. I kindly do not take me.
Do you think we are taking you, Ms?
I don't. Monday week it's a holiday. Great.
Item 21.
I made my submissions on ex parte decree whether, my lord, the defendant who had knowledge about the suit can, my lord, take the stand that the writ of summons was not properly served.
Ah, yes.
I was relying on, my lord, the second proviso to Order 9, Rule
Yes,
39.
If otherwise aware.
Ma'am, for the respondent, I'm being led by Mr. Rupak Ghosh. He's on legs before another.
So you start.
He's far too junior to you, Mr. Mitra.
I was telling him, my lord, a story.
What is it?
What I had to face, my lord, when I was 7 days in profession.
I see. Well, knowing your senior. Yes.
Your Lordship permits me to come back.
Come back when? Tell us.
If your Lordship makes it not today, we'll come back tomorrow or on Monday.
Not today.
Date for Lordship.
But he argues very well. Mr. Kutari argues very well.
Date for Lordship.
He will argue right now, maybe after 2 matters. My lord.
In which Mr. Mitra is my leader.
We have followed that. Otherwise, how could he say?
Item number 22.
Optimal power. Your optimal power? No.
Yes.
Achha. Who is Bharat Heavy?
Well, we are for Bharat Heavy.
Achha. Your optimal power.
Yes. Now, well, this is an MSME award. But I challenged it, but I did not succeed. I am therefore even in appeal before your lordships. Now, well, so far as the MSME is concerned, well, we have to understand one thing very clearly. It does not, my lord, stand in a different pedestal. Well, the MSME Act provides that the Arbitration Act will apply. So, my lord, every award will have to ultimately satisfy all the requirements of, my lord, the Arbitration Act of 1990.
MSME, I only know now Shilpi, I know Mohakali, Gujarat Mohakali, and NBCC.
My lord, I do not know, my lord, what purpose, my lord. This is now the policy of the government of India to promote this sector. And for that, there is a separate statute. And the statute has some very, my lord, burdensome provisions, including, my lord, for provisions for interest. And, my lord, what strangely it says is, my lord, that arbitration, my lord, can be done before the council itself or before, my lord, any other institution.
18A or
Yes,
something.
that's right. Now, my lord, if it is done, my lord, by the council, well, then none of, my lord, the requirements of the Arbitration Act are followed. And, my lord, if your lordship sees, my lord, the nature of pleadings that are filed, my lord, the manner in which the hearing is conducted, the manner in which, my lord, directions are given in the course of hearing, and the manner in which the conclusions are reached, my lord, your lordship will find that there is, in fact, no adjudication at all.
Mr. Shah, will you keep us occupied till 12:30?
Yes, my lord, 12:30.
And 12:30, from 12:30, you will keep us occupied in the other case.
Yes.
So we can release your other runner friends for this half at least.
Yes, ma'am. Lama Pine, one.
That makes Mr. Chaudhary very happy because he can go elsewhere and argue at 12:30. We haven't forgotten our days on the other side.
One great advantage of being a junior was that, my lord, you could make several rounds of several courts and come back.
Correct.
Now, my lord,
Unfortunately, my lord, our days are no longer there, my lord. Before vacation, last 2 weeks, interlocutory court and that court, my lord. I don't know what is wrong, but it is not that what it used to be.
People don't want to litigate that much, very frankly.
no, my lord, most of the litigation has now gone to the tribunals. Most of the litigations, my lord, have gone to the tribunals. My lord, during our younger days, my lord, we were occupied largely by my lord, litigations against banks or for banks. My lord, all of that has gone. It has now gone to the Debts Recovery Tribunal. It has now gone to my lord, Appellate Tribunal. It has gone to my lord, the NCLT and my lord, the Appellate my lord, Forum of NCLT. That chapter is closed. So my lord, company jurisprudence, everything has gone. So my lord, the bulk of litigation in the original side has gone.
Correct, correct.
I'm not talking about my lord, CAT, SAT and the other things.
I remember having counted Mr. Pratap Chatterjee moving 23 unlisted court applications. This was my second year in the profession. Interlocutory court, 12.
Listed application is now history, my lord. It's in the pages of history in the last decade or so. Last decade or so, I don't think there is any concept. Entire concept of unlisted is now.
But there were my lord, flaws in the unlisted system also. My lord,
It was abused. The
yes,
system was abused.
that's
So
it.
it had to be stopped.
Yes, yes.
Yes. Now, my lord, so far as the my lord, one thing is my lord, here, the requirement of my lord, the statute is the same. There is no departure made for MSME arbitrations. Well, if your lordship will kindly have a look at my lord, section 8, well, as your lordship is pointing out once. Section 18 of the MSME Act. Well, this is how it must proceed. Well, just one section is good enough. Well, please have a look at section 18 of the MSME Act.
Yes.
Well, at first, there has to be a conciliation. If the conciliation fails, there will have to be an arbitration. Now, this act applies, even when there is no arbitration clause in an agreement between the parties, an MSME can invoke the provisions of this act and seek a reference to arbitration under the statute. But once it seeks arbitration under the statute, irrespective of whether there is an arbitration clause in the agreement or not, it has to abide by the same process of arbitration. May I just read this? 18.1. Notwithstanding anything contained in any other law for the time being in force, any party to a dispute may, with regard to any amount due under Section 17, make a reference to the Micro and Small Enterprises Facilitation Council. On receipt of a reference under subsection 1, the council shall either itself conduct conciliation in the matter.
Mediation.
Mediation. Now, it is now, of course, here it's called conciliation. Now the word is conciliation.
Now it's conciliation.
Yes.
So now it's mediation.
Now it's mediation.
Earlier it was conciliation. Now it is.
I'm sorry.
Yes.
Change it. I'm sorry, Madam. It's now mediation act. In the matter or seek the assistance of an institution or center providing alternate dispute resolution services, my making a reference to such institution or center for conducting conciliation. And for the purposes of conciliation, the provisions of the Arbitration Act are made applicable. Section 65 to 81, of course, these are now done away with because there is a separate act. Where the conciliation initiated under subsection 2 is not successful and stands terminated, it should be mediation, without any settlement between the parties, the council shall either itself take up the dispute for arbitration or refer it to any institution or center providing alternative dispute resolution services for such arbitration, and the provisions of the Arbitration Conciliation Act 1996 shall then apply to the disputes as if the arbitration was in pursuance of an arbitration agreement referred to in subsection 1 of section 7. I shall not read further. My lord, what is important is, my lord, ultimately, my lord, the Arbitration Act applies with full force even to, my lord, arbitrations that are carried on by the Facilitation Council itself. Now, my lord, in this case, my lord, there was a conciliation that was commenced by OPS, which is the respondents before your lordship. And my lord, they proceeded with, in the usual course of filing, statement of facts. Now, my lord, your lordship would imagine that when, my lord, a statement of fact is filed in a normal arbitration proceeding, well, it will, my lord, proceed to first, my lord, plead the case, the contract between the parties, my lord, the entitlements of the party under the contract, and thereafter how, my lord, the entitlement has been refused or breached. Lord, please have a look at the statement of facts that was filed in this matter. If your lordship will take up the paper book and come to page 36. This is a statement of claim or statement of facts by whatever name called. Well, this is filed under the cover of a letter of 10th July 2018. Yes. Please see page 37. Let kindly come to, well, of course, my lord, this is, my lord, without any paragraph numbers, so, my lord, it will be a little difficult to pinpoint the portions I want your lordships to see. But, my lord, kindly see, my lord, the second paragraph. From 2008 to 2009, BHL ordered further equipment from OPS India as listed. So, my lord, the order for equipment is placed, the amounts are specified. Then kindly skip, my lord, the paragraph after the table. From 2010, BHL orders on OPS can be best understood in three groups, and this statement of facts has compiled the claims into the groups as follows. Miscellaneous projects 2013 to 2014, then multi-megawatt solar photovoltaic power sites around India, and then upgrade of solar power plants at various Lakshadweep islands. The narrative follows these categories in the three sections. Now, please see, the projects are now itemized. Miscellaneous projects, years 2013-14. What is their claim in respect of these projects? Between 2013 and 2014, BHEL awarded OPS various smaller projects. These are listed below in Table 2 and were completed by OPS India. These contracts were delivered and completed within the required time frame, installed, commissioned, and handed over in the period of years 2013-14. Now, this is their complaint. Despite having no reported issues on these projects, BHEL has not paid these amounts and has refused to discuss or attend meetings to solve the matter. What are the, my lord, amounts? Please see purchase order. First one is dated 24th February 2014. The amount is 1,06,304 only. But, my lord, please see now, description. ET Bangalore retention and IC. So, my lord, this is the retention amount that they are claiming. Next, my lord, purchase order, 17 June 2013. 1,38,104. Kanchipuram retention and IC. And, my lord, then 16th February 2013, 9,34,917. Bhilai, 15% supply, 10% retention. Now, this is what, according to them, was outstanding in respect of these three projects. Above is made up of 10,07,677. Amount owed is 1,71,647 in interest. So they're claiming it with interest, my lord, in terms calculated in terms of the MSME Act, which is, my lord, exorbitant. Be that as it may. Then, my lord, the next set of projects. Multi-megawatt solar photovoltaic sites. From 2010, BHEL invited OPS to participate in a number of online reverse auctions for these 4 contracts consisting of 6 sites. OPS India was successful bidder on these contracts through reverse auction. OPS India supplied 19 megawatt of equipment for these 4 projects. Now, my lord, this is very important. However, despite winning the contracts in open competitive bidding process, BHEL then requested OPS to a negotiation meeting and insisted on a 40 lakh price reduction for the supply of first 10 megawatt or 40 into 250 kVA PCUs with SCADA. This was the start of the increasingly heavy approach taken by BHEL towards its vendor suppliers. These contracts were for supply of equipment with SCADA and installation. So the contract is for supply of equipment with SCADA and installation. It became quickly clear that these major MW megawatt sites were suffering from many design, management, and contract issues. Well, the first admission here is, they say that the sites were having issues, which impacted their ability to work. It became quickly clear from 2012 that these major MW sites were suffering from many design, management, and contract issues. Then, part A1, installation of OPS equipment. BHEL, other contractors installed OPS equipment incorrectly, as can be seen below. They next some photographs from which nothing can be understood. So, first they say there were issues at site. Second, they say that other contractors installed OPS equipment incorrectly. Then please see 5. The effect of this installation mistake was that the equipment would operate in overheated mode and tends to shut down under over temperature effect. So, the admission is that the equipment that they supplied would overheat and shut down. As a result, BHEL called upon OPS India project team and insisted that OPS India, at its cost, install a major air cooling duct system at the site. While disputed with BHEL, it resulted that OPS India felt forced to incur these costs at all the sites. The cost of this cooling duct was about 15 lakhs at each site. OPS should have received a variation order or amendment order to cover the cost of these ducts. Image shows extensive ducting work needed to try and blow cooling air. So, they say that they were given an opportunity to correct the defect by installing air conditioning systems. Now, please see 7. Ultimately, these ducts did not work very well, as the control room area was also very dirty, and a high degree of dust and dirt gathered in the equipment, causing more problems. So, they were given an opportunity to rectify by putting air conditioning systems. They attempted to do so, but it did not solve the problem. Then, photographs are again annexed, which again is completely indecipherable as to what these photographs show. Then, paragraph 9. Based on these installation issues, a high level of dirt gathering in the equipment, poor local grid conditions where this would interrupt the power generation, there were some failures due to all these circumstances. Again, admission that the equipment did not function. OPS India continued to remedy the problems at its expense and investigated at its expense an upgraded design of some internal sections to withstand these extreme conditions. These experimental upgrades were quite successful, but then BHEL insisted that OPS India upgrade all equipment at all sites at OPS India expense. This was not feasible or fair under all circumstances. OPS worked up to 2015 on continual repairs and incurred very high ongoing costs for replacement parts. On 29th May 2015, OPS Chairman OPS India, Stephen James Phillips, came from Australia, visited Raura plant at Rajasthan to support BHEL. He reviewed with the Australian engineering team and recalculated airflow and thermal modeling of the control room and advised BHEL for certain changes. Site visit report is enclosed for understanding of the real situation. Temperature at Raura in summer season normally goes up to 45 to 48 degrees centigrade. There was huge accumulation of dust particles and sand. Though the control room at Raura site was designed and built by BHEL only, just to help BHEL in the project, OPS took this initiative. So, here, up to this, your Lordship has seen, this, is, so far as this is concerned, this is part A1, installation of OPS India equipment. Now, the admission up to this stage is that the equipment did not function or did not function effectively. Attempts were made to remedy the equipment, opportunity was given to remedy the equipment, did not work. Their problem is that the other contractors did not work properly. There was heat, there was dust, and there was other complications at site for which their equipment did not work. But the admission at the end of the day is their equipment did not function. Then, please see the next item, part A by 2, which starts from paragraph 14. On each of the megawatt projects, OPS India was also contracted to provide a control and monitoring computing system. This system, this control and monitoring computer system is called SCADA. For Raichur, 3 megawatt sites, OPS India had built this SCADA equipment as per the contract, And suddenly, prior to delivery, OPS India was asked not to supply the SCADA for Raichur site. OPS India, on insistence of BHEL, proposed a price set-off for the SCADA equipment at rupees 5 lakhs, but BHEL wanted to deduct 15 lakhs for SCADA as they wished to install a SCADA of their own. The reason for this was that their systems were not working. So we said, do not supply, we shall install our own system. This was suggested as unilateral adjustment to the contract that OPS India resisted. Finally, due to prolonged non-payment by BHEL side, a set-off of 10 lakhs was agreed upon by OPS India. So this set-off is agreed for non-supply of the SCADA system. Ultimately, over and above 10 lakhs, BHEL deducted 7.36 lakhs extra by showing loss energy generation as a cause, which was never a part of OPS India contract with BHEL. So there is loss of energy for which a deduction is made. Now, my learned friends do not make any reference to the contract or the contract provisions at all. They only say that so far as SCADA is concerned, we did not supply SCADA. It was taken outside the scope of our contract in Raichur. For that, there was a set-off or given. And finally, there was a deduction because of loss of energy. Now, please see, what is the claim? There's a tabular claim made. Now there's a purchase order, which you'll also find is dated 7th February 2014, for which the claim is only on account of service tax payment due, 47,759. Then, there's a purchase order of 27th January 2012, for which, the claim is 28,37,000, 10% retention, and operation and maintenance pending payment. The retention amount was really in the nature of security performance. And operation management, they never performed. They abandoned the site. Then, please see. So, the claim is retention and operation maintenance pending payment. Again, the next purchase order is 7th February 2014, 20,11,713, Raichur, retention, partial payment, operation and management due, short payment. No particulars of which is for what. Table 3, here the total amount is tallied. You'll also see that it is now 48,96,950 in the earlier table. Now, please see paragraph 15 onwards. In November 2017, BHEL replied to an OPS India request for payment of accounts. Reply from General Manager Mr. Gupta was received. He quoted various issues that are all broadly explained above. For example, penalty for loss of power generation can be seen through poor state of the total project. This is not OPS fault. Now, there has to be therefore an adjudication of whose fault it is. Whose responsibility was under the contract. Till now, your lordship has not found any reference to the contract or the obligation under the contract or why it is not their fault. This is not OPS India fault. Most of the other problems can be seen through the issue of overall site management and total EPC design issues. Their complaint is, this was a result of the design issues and site management issue. Then please see, at paragraph 17, I should skip paragraph 16, not important. BHEL has often claimed loss of energy generation for OPS equipment, which never was a part of the contract with OPS India. The issues, however, as shown above, were all site-related problems, which in turn caused loss of energy generation. BHEL was trying to blame OPS for this issue and tried to penalize the small company for reasons best known to them. OPS India considers this act of blame as unfair and unfortunate for a small company. In fact, OPS India was vendor registered with BHEL under MSME, and each year a certificate in this respect had to be submitted. So, here we find that there is loss of power generation and there is a blame game as to who is responsible, but they ultimately say that this was a site-related issue and a EPC contract issue. Then next, they talk about the Raura PV site, that's annexure 2. Raura PV site is also covered within this claim, because Raura is a part of well, this annexure A2. Then, well, please see Lakshadweep Island project. Now, well, please see page 43, the second paragraph. This work was done and completed by OPS India. Now, very important. The same purchase orders include an annual operation and maintenance contract where OPS India would be engaged and be responsible for operation and management of different listed islands of Lakshadweep. For everyone's benefit, a local third-party contractor was employed by OPS India who had carried out the basic O&M on this OPS supplied equipment. Arrangements around the OM, now this is very important. Arrangements around the OM were very difficult as the invoicing would be accepted on yearly basis, but effectively paid around 90 days after submission of yearly O&M invoice. Contract with the third-party contractor was eventually on quarterly basis, as the contractor would not accept waiting a year and a half for this moment. It was extremely difficult for OPS India to pay the third-party contractor quarterly basis when the payment from BHEL side was yearly basis only, and that also 3 to 6 months delay in payment. OPS India tried to renegotiate with BHEL regarding the OM contract without any positive result. Later, OPS India requested BHEL for at least quick or immediate payment on yearly basis OM's invoices. Somehow, all efforts were in vain, which resulted in non-payments, penalization, and ultimately stopped work many times at Lakshadweep Islands were quite difficult and costly sites. Despite efforts in 2014-15 to negotiate and renegotiate a better arrangement with BHEL, this was not agreed by BHEL, as they became increasingly reluctant to modify any arrangement, even when it would result in better service to them. With time, it became extremely difficult for a small company like OPS India to continue to support this O&M support activities. So, my lord, what happens is they say that the contract terms were not favorable to us. We tried to negotiate, we tried to renegotiate, we request you to modify the terms of contract, you did not. We ultimately stopped work. Now, my lord, the summary of the claims in this part is, my lord, please see 17,63,748 and my lord, 28,37,620, total 46,01,368. Now, my lord, so far as this is concerned, my lord, this is on account of operation maintenance contract they could not perform at all. And my lord, these are all admissions. So they say that, my lord, power loss, I am not at fault. It was your site. It was your other contractors. They say Lakshadweep, operation maintenance, you did not modify the terms of the contract. We could not perform. And they say that so far as the first is SCADA equipment is concerned, you descoped us. You gave us a set off. But so far as that is concerned, again, you deducted monies. And first, my lord, they say that we could not perform because your equipment or your placing was wrong. Now, my lord, all these are matters which therefore required adjudication from the contractual perspective. Now, your lordship will be surprised to find that there is no adjudication of any nature whatsoever. Now, please see, ultimately there is a tabulation of the claims. At the table which your lordship will find starts at page 44.
The council itself conducted the arbitration.
Yes. And what is strange is that today there is ABC who are in the council as arbitrators. Tomorrow it's CDE. The third day it's DEF. And that is how it proceeded. But that your lordship will find from the minutes, which I shall show you, lordships. And ultimately, it is worse than what a Qazi would do. The sympathy, of course, is naturally with the MSME. They perhaps have, ultimately, under instructions to provide all support to the MSME. That does not detract from the fact that arbitration must be conducted according to the norms of arbitration.
You want to switch over?
Yes, I'll do.
Are all parties here? Nobody is here.
Most of them are on the virtual mode.
Oh, dao link dao dekho. দেখো আইটেম অত দূরে সরিয়ে দিয়েছে কেন?
Monday to Monday. Well, so far as this matter is concerned, well,
yes, tell us.
Well, Monday I'm in some difficulty. Tuesday, Wednesday, whenever you.
Not tomorrow.
Tomorrow I can do. But no, only tomorrow, these broken benches, which ultimately give some difficulty.
Oh, also tomorrow this bench is there only for the first half.
Right.
After that we break also.
Well, kindly
Tuesday.
keep it Tuesday, Wednesday, whenever you. Tuesday.
Mr. Jishnu Shah, Kamalanit Senior Advocate representing the appellant, opens his submission but does not conclude. Opens his argument but does not conclude. Paragraph. As requested, let this matter be listed again on Mongolbar date. Retaining his position.
This matter item number 16 and 17.
Lord, I appear for defendants, respondents 1 and 7. Before my Lord learned friend start, there's a small preliminary objection. If your lordships permit, I'll just state what that preliminary objection is.
Yes, please do.
Lord, my lords. Lord, this was the suit which was filed under section 92. There was a direction from the appellate court that this
Counsel,
matter preliminary point which is raised should be heard.
Mr. Counsel, there's always a connectivity issue. There's always a connectivity issue. It's much better that you come physically and argue it. We'll hear you today, but half of what you are saying we can't understand because it's breaking. It's breaking.
I'm so sorry, Lord. My apologies, because I believe there's some bandwidth issue generally. So I apologize for that. Lord, all that I wanted to say is that there is a preliminary issue where the leave has been revoked under section 92. So until that leave is restored, the question of interim relief would not arise.
My lord, first let me have, my lord, the suit, my lord, restored. Then, my lord, I shall argue because all the issues that my learned friends are arguing and all the issues that my learned friend have argued and will argue are all preliminary issues. My lord, they have refused to enter into the merits of the matter because there is nothing to say on the merits of the matter. Now, my lord, may I start? Now, my lord, so far as this matter is concerned, my lord, this concerns, my lord, the Lamartine schools. Well, the Lamartine group of schools, well, there are 3 schools now, one, my lord, set of schools in Calcutta, one in Lucknow, and one in Lyon in France. They were all set up, my lord, under bequests left behind by, my lord, a gentleman called, my lord, Claude Martin. He was a major general of the, my lord, East India Army. He left, my lord, very substantial sums of money by his will, my lord, made in the year 1800. Now, well, in 1800, he, my lord, dedicated a sum of 2 lakhs of rupees for setting up a school in Kolkata. Well, I imagine what 2 lakhs of rupees in 1800 would be. Now, my lord, this will, which I shall, my lord, later take your lordships to, my lord, did not say it would be a Christian institution. On the contrary, if your lordships look at the will, it certainly made provision for Christian children, my lord, particularly, my lord, what we have later come to know as the foundationers, who would be, my lord, ultimately supported by the school. My lord, they would be free students, provided free boarding and education. My lord, this, my lord, said that you will make some provision for Christian students, but did not say it would be a Christian institution. Now, my lord, this, my lord, will, my lord, ultimately did not set up the school. It only, my lord, left behind a bequest. My lord, this ultimately, my lord, led to the court, my lord, establishing the school, my lord, by itself. My lord, this happened, my lord, by a decree of 1832. My lord, that, my lord, your lordships will find later. I shall take your lordship to that at page 163 of the stay application. But, my lord, for the time being, my lord, please just know that the school was established by a decree, my lord, which was then passed, my lord, by the Supreme Court, my lord, which is in Bengal, seated in Bengal. 22nd October 1832. Well, this provided for a manner of governance of the school. So, my lord, what happened is, my lord, the court, my lord, really my lord, established a school, and the school is, my lord, a school which is, my lord, really for charitable purposes. It was a charitable institution. So, my lord, it became, my lord, a constructive trust. Now, my lord, the trust has to be managed. My lord, since, my lord, the founder of the school, my lord, who left behind the bequest in his will, did not himself, my lord, set up the school or provide for its management, the court in its decree provided as to how the school would be managed. Now, my lord, this decree, my lord, was modified by a decree of, my lord, 6 June 1944, which is, my lord, important, that your lordships will find at page 181. My lord, before I take your lordships through that, my lord, may I just, my lord, tell your lordship that what essentially this did was to, my lord, ultimately provide for, my lord, the management of the school by a board of governors. It provided that there will be 12 ex officio governors, my lord, who will manage the school. Ex officio because, my lord, they will be appointed governors according to their status, my lord, or the posts that they hold in society or in service. Now, my lord, 12 ex officio governors who will also every year elect, my lord, 4 additional governors, my lord, whose, my lord, appointment will, my lord, be invalidated after the end of the year, and, my lord, 4 fresh additional governors will be appointed. Now, my lord, interestingly, if your lordship will kindly just straight away come to, my lord, page 77A, which is, my lord, at part 2 of, my lord, the paperwork of the stay application. This is a part of the decree of 1944, modified decree of 1944. A. It will volume 2 thirds. 186. Oh, I'm sorry, page 186. 186, not 77. No, 186. Well, please see this one page. This is, my lord, a part of, my lord, the modified decree of 1944. My lord, this is by the High Court of Judicature, my lord, at Port William. May I just read, my lord, this portion. My lord, please see the top of the page where it says, or, my lord, may I just, it states, by virtue of the decree made in the above suit dated 22nd October 1832, then, upon reading a petition of the Advocate General of Bengal and his affidavit in verification thereof sworn on the 28th day of February last, and the exhibits annexed to the said petition and marked respectively A, B, and C, all filed this day, and upon hearing Mr. Remfree, Advocate for the Advocate General of Bengal, it is ordered that notwithstanding anything contained in the decree made in these suits and dated the 22nd of October 1832, or in subsequent decree or order of the late Supreme Court, or of this court, whether such decree or order is on record or not, His Excellency Viceroy and Governor General of India shall be the visitor of La Martiniere School, Calcutta, and there shall be 12 ex officio governors of the said school, in substitution for the governors appointed by any such decree or order in these suits as aforesaid, such 12 governors being, Namala, this is very important. Number 1 is His Excellency the Governor of Bengal. The post no longer exists. Then, the Honorable Chief Justice of Bengal. Post does not. No. Well, this is the His Excellency the Governor of Bengal. This is West Bengal. But it is the then Bengal. Then the Honorable Chief Justice of Bengal. Then the Most Reverend Lord Bishop of Calcutta. This post exists. The Honorable Member of the Viceroy's Council in charge of Education does not exist. One of the members of the Executive Council of His Excellency the Governor of Bengal to be nominated from time to time by His Excellency the Governor. Not there. One of the puisne judges of this court to be nominated from time to time by the Chief Justice. Well, it is then the Supreme Court. Not there. The Advocate General of Bengal, not there. The General Officer in Command of the Presidency Brigade, not there. The Director of Public Instruction Bengal, not there. Chairman of the Corporation of Calcutta, well, it is no longer the Chairman of the Corporation of Calcutta in the sense that it exists. A Minister of St. Andrew's Church of the Church of Scotland in Calcutta, duly nominated by the session of the said church. Well, this post is still there. The President of the Bengal Chambers of Commerce, not there. So, out of these 12, 10 posts do not exist.
Chamber of Commerce, not there.
The President of the Bengal Chambers of Commerce, the Bengal Chamber of Commerce, as it was at that time, because they have not said that there is any such ex officio member who is available from there. But at the end of the day, what is the accepted position is, and that is also accepted from the pleadings, is that there are two persons, who are still entitled under this scheme.
3 and 11.
3 and 11. And one is the bishop, and 2 is the presbyter of the St. Andrew's Church, who is under the bishop. Now, effectively, therefore, the school is being managed by one person. One person and his proxy, who is the second person. Now, if your lordship will see, it is in line with this that ultimately the constitution of the school was framed. That is at page 157, 270, I'm sorry. That is 270, also a part of the same volume.
$270, yes. When was this framed constitution?
Well, the constitution was framed. We don't have any exact date, but if your lordship sees 271,
yes.
Well, please see the top of the page. The Constitution, the second paragraph. The Constitution of La Martiniere Schools is based on the will of General Claude Martin and the judgment of the Supreme Court mentioned above. The Constitution will be further construed and interpreted by some other judgments of the High Court at Calcutta mentioned below. Well, Honorable Mr. Justice Ghosh, 1st February 1968, in such and such. Salient points of the Constitution are set out. Then, my lord, please see the Board of Governors. The Board of Governors shall consist of 12 ex officio governors and His Excellency Viceroy and the Governor General of India as visitor. It has to be, my lord, before independence. So, my lord. Now, my lord, after that, your lordship will find that same 12, my lord, posts are mentioned.
As in the modified decree.
Yes. Now, my lord, important, my lord, one important part is page 273. My lord, even if, my lord, some doubt exists as to whether, my lord, the Bengal Chamber of Commerce still exists, or, my lord, the President of the Bengal Chamber of Commerce can be, my lord, ex officio, my lord, this is undone by, my lord, the second part of the decree, which is reproduced in the Constitution. Please see page 273. Well, this is also the decree of 1944, which is again pre-independence. No person for the time being or officiating in any of the said offices mentioned above who does not profess the Christian religion shall be eligible to exercise or perform any of the powers and duties of ex officio governors, and other ex officio governors shall exercise and perform their powers, duties, as if such persons had been appointed, but upon the same office being held by a person where substantively for officiating protesting Christian religion. Such person shall be entitled to exercise and perform powers. So, my lord, here, my lord, even if some positions exist, my lord, but they are not manned by, my lord, people of Christian faith, they will not be entitled to hold office. So, my lord, that is why even if your lordship ultimately says that Bengal Chamber of Commerce still exists, well, ultimately, my lord, if they are not manned by people of Christian faith, they don't have the right to be ex officio governors of the school. So, my lord, effectively, it boils down to two persons. And, my lord, through the process of, my lord, subordination to, my lord, the bishop, one person. Now, my lord, after that, if your lordship sees, my lord, here.
But factually speaking, is there a board of governors today?
One person, two persons.
Two persons on the board.
Yes. Bishop, presbyter. Now, my lord, my lord, just go back to my lord. Here, my lord, for this, my lord, your lordship will find additional governors page. No, from the constitution. My lord, now, my lord, so far as the board of governors is concerned,
Who are you? Who are you, Mr. Shah?
My lord, I am, my lord, persons who are, my lord, ex-students of the school, and my lord, persons who had been appointed to, my lord, the board of, as additional governors to the school. I don't, my lord, profess any right to permanently occupy any post. Because, my lord, when I filed the suit, my lord, I filed the suit as person interested in the school. Because, my lord, I am amongst other ex-students, my lord, people, my lord, who have been associated with the school.
How many of you?
4. My lord, these 4 were appointed as, my lord, the additional governors. Now,
by the board?
Yes, my lord. Now, my lord, if your lordship will kindly have a look at page 276 once.
Are you still on the board?
No, I cannot be. My lord, beyond 1 year, I cannot be. Please see 276 once.
Hey, 276.
Same volume.
Oh, এখানে আছে.
Same volume.
আচ্ছা.
Well, at the board of acting governors at the top of the page.
Yes.
And this code doth further order and decree that the said ex officio governors shall annually elect and nominate 4 additional governors who shall during the year for which they shall be so nominated and elected have equal power and authority with the ex officio governors of the said school in the management and direction thereof and in all matters relating to that. So, the school is to be managed by 16 governors, 12 ex officio, 12 nominated, 4 nominated. These 4 nominated governors hold office only for a year. If today I am now nominated as a governor, and I hold equal powers with the ex officio governors, naturally, I cannot be removed unless all concur. Kindly consider this for a moment. 2 ex officio governors, 4 additional governors. What, my lord, ultimately led to the filing of the suit? Because, my lord, this situation has been going on for some time. My lord, ultimately, the things came to a boil because what happened is, my lord, there was a change in the bishop. A new bishop comes. The new bishop comes and he is one of the 2, my lord, ex officio governors. He suddenly removes all the 4 acting governors, additional governors, which could not have been done because all of them hold equal power for the year. They are removed.
In the constitution, there is no provision for removal of additional governors. Acting governors.
On the contrary, it says very clearly that the acting governors for the year shall hold equal power. But, my lord, we are not on that at all. Because, my lord, these additional governors, my lord, they filed the suit. And if your lordship sees the first, my lord, 28 pages of the complaint is ultimately with regard to the administration of the school. The complaint is with regard to the mismanagement of the school by, my lord, this coterie of 2. And, my lord, the complaint is that today there is imminent need in view of, my lord, the provisions of the, my lord, constructive trust that has been brought about by the scheme of the High Court, my lord, expressed through its decree, that, my lord, the school will have to be managed by 16 people, of which 12 will be ex officio, 4 will be additional governors who will retire by rotation. My lord, they did not say that we want to hold on to office. They said that we have been wrongfully dismissed from office. And this only goes to show as to how the school is being administered. And ultimately, they ask for scheme. Because, my lord, the scheme has to ultimately subscribe to, my lord, the requirements of the trust that is created by a decree of the court. Now, my lord, when this suit is filed, and, my lord, the suit says that the school is to be run by 12 plus 4. And we effectively have only 2 persons now running the school. And these 2 persons are now nominating 4, who are obviously, my lord, people who owe their allegiance completely to these 2. My lord, we have effectively only 2 or 1 person running the school. Ex officio 2 plus 4 who are their nominees. So, my lord, effectively we have, my lord, 6 people at best, which, my lord, ultimately through the process of, my lord, allegiance, my lord, boils down to 1. Now, my lord, our, my lord, representation before the court was that if this is, my lord, the trust deed, if the decree is the deed of trust, and if the school must be managed in accordance with the, my lord, terms of the deed of trust, which is the decree, and if, my lord, ultimately the deed of trust becomes unworkable in the sense that, my lord, these posts do not exist, or, my lord, persons of Christian faith cannot be found in these posts, in that case, the decree has to be modified again. And, my lord, so far as this is concerned, we, my lord, went to court and we, my lord, flagged various issues from time to time. For example, suddenly we found that in Behala, there was an Oxford Mission school which had been, my lord, granted the permission to run as La Martiniere Oxford Mission. Then, my lord, we found that, my lord, people were being taken in and fired recklessly. Board of governors were being appointed, my lord, and, my lord, they were attempting to, my lord, discharge by, my lord, functions without authority. Rampant, huge siphoning of funds, my lord, which of course is not, my lord, something that we need to flag before your lordship. But, my lord, at the end of the day, the question is, my lord, what is, my lord, the manner in which the school has to be administered? Can it be kept at 2? And, my lord, these 2 will appoint 4 at their will? Or ultimately, will it have to be, my lord, my lord, board of governors 12 plus 4 elected or nominated by 12 people, not by 1? Now, my lord, when this matter, my lord, was brought to court, what was the objection of my learned friend? Now, my lord, your lordship will see that, my lord, the bishop, well, I do not want to, my lord, make it an issue, but, my lord, what is on a matter of fact is your lordship will find that counsel from all across the country have been engaged to argue for the bishop in this matter. They, my lord, come at a cost. And, my lord, what are their objections? They have not said one word as to why, my lord, neither in the pleadings nor in the course of arguments as reflected in the judgments. Not one word as to why the school should continue to be run by this coterie of 2. They first say that your suit is not maintainable under section 92 of the Civil Procedure Code. We answer that, my lord. 2 courts, my lord, have already answered that question. Then they say you could not have filed the suit as a representative suit under Order 1, Rule 8. My lord, why representative? Because ultimately all persons who are interested in the affairs of the school, my lord, have to be made parties. And, my lord, the La Martiniere Association of Alumni of La Martiniers has, my lord, sought to be added as a party and were added as a party to the appeal. They are also the other appellant. There are 2 appeals before your lordships. My lord, they are, my lord, here happily. We are here a little unhappily because we are all pro bono and they are, my lord, not pro bono.
Yes, one is khep, one is akhep.
Now, my lord, your lordship will see, my lord, this is the, my lord, real difficulty. Now, my lord, initially, my lord, while these, my lord, 4 additional governors still had, my lord, term left in their 1-year period, my lord, there was an interim order that was passed by Justice Arindam Sinha, my lord, who was then taking up the matter. And his lordship says that the school will not, my lord, function.
When were the plaintiffs elected as acting governors?
Well, that was, my lord, in the year, well, 2019. Appointment letter. 281, page 281, your lordship will find the pages. March 2019.
And during the 1-year tenure, they were removed?
Yes, much before the expiry of the period. So, my lord, they come up and they file the suit. 19th March appointed, June removed.
The suit was filed when?
My lord, the suit was filed in, my lord, July
2019.
Yes.
You obtained any interim order in the suit?
Yes, my lord. Now, my lord, your lordship will please see, my lord, some of the orders that were passed. Well, if your lordship will please take up volume 3.
রাখো রাখো
Yes. My lord, by this order at page, my lord, 319, 4th July 2019, my lord, leave under order 2 rule 2, leave under order 1 rule 8, and leave under section 92 were granted.
Page
Page 319.
319.
4th July 2019, leave is granted under, my lord, order 2 rule 2, under section 92, and under order 1 rule 8. And that is because, my lord, our argument was that, my lord, ultimately, this is a trust established by the High Court. And, my lord, the High Court has, in the matter of, my lord, public charities, my lord, a parent's patry jurisdiction which it exercises. I shall, my lord, show your lordship the decisions on that. My lord, next.
The suit in which that decree was passed, setting up the trust, as it were, that suit was disposed of ever.
My lord, there is, my lord, that is where the confusion is. My lord, Justice Boshak, my lord, when his lordship was hearing this matter in appeal, my lord, in one of the matters, his lordship, my lord, called for the records. And, my lord, his lordship was of the opinion that the suit had been disposed of. My lord, my lord, the old equity suit, my lord, in which, my lord, the original decree was passed, my lord, that is surviving. My lord, a subsequent, my lord, suit in which, my lord, it was modified, that was disposed of. But, my lord, there was a decree which said that, my lord, you can apply in any suit. Now, my lord, in any event, my lord, may I, my lord, take it this way? Section 92, my lord, that is, my lord, the suit which set up the trust. Now, my lord, under section 92, my lord, any person interested in a public charity, my lord, can apply, my lord, if ultimately it is in the interest of the trust itself. My lord, independently I can apply, my lord, that I shall show you, lordship. The suit was dismissed only upon, my lord, learned single judge forming the opinion the old equity suit survives. So, my lord, my suit was dismissed. With the greatest of, my lord, respect.
No, it survives, so you should apply in that suit.
My lord, with the greatest respect, my lord, that is perhaps not, my lord, the law. Because, my lord, today, what is that suit? That suit is the suit which ultimately establishes, my lord, the decree.
So the learned judge doesn't deal with the merits of your
Not
claim.
at all. Not at all. And, my lord, this notwithstanding the fact that, my lord, there is, my lord, a comprehensive, my lord, answer on the merits of the matter in, my lord, interlocutory proceedings, of course, by, my lord, 2 other judges of this court. And, my lord, they have also passed orders saying that, my lord, the Board of Governors will not function at all except for carrying on day-to-day, my lord, business of the school. Now, my lord, as soon as the suit is dismissed, they appoint 4 further additional governors. Because, my lord, the additional governors that they had, my lord, appointed were, my lord, denuded of their powers, number 1. Number 2, my lord, their term had come to an end. And, my lord, no new governors could be appointed. As soon as the suit is dismissed, 4 additional governors are appointed. And, my lord, again, my lord, everything is happy and merry.
Sorry, we digressed. After this suit was instituted with leave under clause 12, etc.
Yes.
Was any interim protection granted?
Yes, my lord, we'll kindly have a look at page 450. My lord, this is, my lord, in volume 4 now. Well, at 450, if your lordship sees, well, at here, well, at the school, my lord, appeared, well, through Mr. Shaktinath Mukherjee, and, my lord, said that, my lord, the leaves should be revoked. My lord, reference your lordship will find is made to the old equity suit. Please see, my lord, at page 451, my lord, third, my lord, the last paragraph. My lord, this talks about, my lord, the will, and my lord, then the decree of 1832, and my lord, then the ex officio governors, etc. Now, my lord, I will not trouble your lordship with these. Then please see 453, second paragraph. Well, from the very beginning, the attack is only on technicality, not on the merits. The last paragraph at page 453, Mr. Mukherjee, learned senior advocate appearing on behalf of the defendant numbers 1 and 2, moves his client's application for revocation of leave granted under section 92 and order 1 rule 8 of the Code of Civil Procedure. Application is such and such. Mr. Mukherjee submits the suit cannot be said to be one under section 92. Once that has been held, consequently leave under order 1 rule 8 of the court should also be revoked. Then, my lord, he relies on certain judgments. But I will not trouble your lordship with that. Then, my lord, please see 454, second paragraph. Mr. Mukherjee on merit submits his client would want to file an affidavit without prejudice to maintainability. He hands up a copy of the minutes dated such and such of the Board of Ex Officios Governors of School with a copy. Minutes states inter alia, since installation of Right Reverend Dr. Probal Kantu Datto as bishop in 2018, there had been a series of administrative and other erroneous acts committed, etc., etc., etc. Now, my lord, on perusal of the reliefs, that is at page 455, second paragraph. On perusal of reliefs claimed in the suit, it does not appear that decree has been claimed for removing any trustee or appointing new. Plaintiffs have challenged letters by which appointment was said to be bad. Well, that is the appointment of additional directors in their place and state. They have as a consequence also challenged appointment to some of the defendants' additional governors. Now, the court then peruses the documents. Well, then please see the last paragraph at page 455. Or I should say something. Well, please see the second paragraph. On perusal of the reliefs claimed in the suit, it does not appear that the decree has been claimed for removing any trustee or appointing new. Plaintiffs have challenged letters by which their appointments were said to be bad. They have, as a consequence, of also challenged appointment of some of the defendants as additional governors. Must be recorded that Mr. Shah was requested to confine his submissions to those pertaining to plaintiffs, as he wanted to also make submissions regarding removal of inter alia defendant number 9. Since the suit does not relate to the plaintiffs seeking appointment or removal of governors involved in the management of schools established as the aforesaid, court is inclined to revoke and revokes leave under section 92. My lord, 92 leave was revoked. Later, my lord, it was reinstated. I shall show you, lordship. Then, my lord, please see the last paragraph. Court has perused 2 documents bearing signature of continuing ex officio governor. Persons who can officiate as ex officio governors have been described in the decree and amendment order. It is unfortunate that one such person has signed 2 documents, contents of which contradict each other. Court will not comment further. Nothing has been shown from either the decree or the amendment order that appointments made by ex officio governors can be undone. Plaintiffs are entitled to an interim order. The Board of Governors of the schools will not take any decision regarding management of the school's disposal of the application. Ex officio governors will not in that time appoint any person as additional governor. Well, this was the interim order passed. Then, my lord, this was taken up in appeal because, my lord, leave was revoked and only a very limited interim order was passed. My lord, here, my lord, the appeal was, of course, my lord, preferred by the plaintiffs. That your lordship will find at page 457. There was also a parallel appeal by the bishop. 2 appeals came to be filed against this order. That is at page 457.
What is the nature of leave under section 92? Without that leave, the suit can survive. If not, then how, after revoking section 92 leave, how could interim order be passed? I'm trying to understand.
No, my lord, so far as the suit is concerned, my lord, the suit can be for a personal cause of action.
Yes.
My lord, for which leave under section 92 is not required. Now, my lord, here the court, my lord, was of the opinion that you are ultimately challenging your removal from office.
I see.
So, my lord, the suit survives to
personal.
My lord, section 92, my lord, the language is, my lord, quite clear. If I may trouble your lordships once with, my lord, section 92. Kindly see the expanse of the section. In the case of any alleged breach of any express or constructive trust, it has to be only an alleged breach, not even a breach per se. In the case of any alleged breach of any express or constructive trust created for public purposes of a charitable or religious nature, or where the direction of the court is deemed necessary for administration of any such trust, the Advocate General or two or more persons having an interest in the trust and having obtained the leave of court may institute a suit, whether contentious or not, in the principal civil court of original jurisdiction or in any other court empowered in that behalf by the state government within the local limits of whose jurisdiction the whole or any part of the subject matter of the trust is situated, to obtain a decree. Kindly see. A, removing any trustee. B, appointing new trustee. C, vesting any property in a trustee. C is directing a trustee who has been removed or a person who has ceased to be a trustee to deliver possession of any trust property in his possession to the person entitled to possession of such property, directing accounts and inquiries, declaring what portion of the trust property or of the interest therein shall be allocated to any particular object of the trust, authorizing the whole or any part of the trust property to be let, sold, mortgaged, or exchanged, settling a scheme, or granting such further or other reliefs as the nature of the case may require. Very, very, my lord, expensive. Your lordships can, my lord, pass any direction that your lordships feel necessary for the proper administration of the trust.
Can also alter the object of the trust. The Prey doctrine.
Yes. My lord, in fact, frame a new scheme, settle a scheme.
Yes.
Now, my lord, the matter is carried in appeal. Your lordship will find at page 457. There are two appeals preferred.
Page
457. Same volume 4.
19 May. টাইমটা বলো।
Well, the first appeal is by the plaintiffs in the suit. The second appeal is, my lord, by the bishop. That your lordship will find from the cause title of the order.
Mr. Paritosh Sinha is appearing for?
The school, for the bishop.
For Reverend Paritosh.
Yes. He has now ecclesiastical inklings.
Very well.
Now, my lord, the first, my lord, part just records, my lord, the interim order. Then page 458, second part, second paragraph. My lord, the third paragraph. First of all, we deal with the order revoking leave under section 92 of the code. It goes to the root of the suit in our prima facie. I'm sorry.
Propose to continue or come back?
Yes, I'll continue, my lord, if your lordships are not otherwise engaged.
Come back at 2 o'clock.
Grateful.
See you.
I was at page 457 of volume 4. This says the joint appeal.
Other side কি হলো যারা ভার্চুয়ালি ছিল আরেকজন ছিল যে
My Lord, Senior Counsel Mr. Nadkarni is on his legs in some other court millers I have joined.
Very well.
I'll be noting the arguments, my lords.
Just তোমার লিঙ্ক এলো কি এলো না আমাদের মাথায় ব্যথা থাকে তো লিঙ্কটা যেন দেওয়া থাকে
This is the order I was last placing before your lordships.
Yes.
Page 457, my lord, 2 appeals. One preferred by my lord, the plaintiffs in the suit and the other by the bishop. Your lordships were last looking at page 458. Well, a third paragraph, well, with regard to the question of section 92, leave under section 92. First of all, we deal with the order revoking leave under section 92 of the code. If it goes to the root of the suit, in our prima facie view, this revocation amounts to dismissal of the suit or rejection of the plaint virtually. Averments in the plaint and the relief sought invite more extensive arguments as to whether the present suit is maintainable under section 92 of the code. At the interim stage, this leave ought not to have been revoked. The question whether this leave under section 92 was granted properly or not shall be decided as a preliminary issue at the time of trial of the suit. That part of the impugned order revoking leave is set aside. So that goes. The suit challenges the resolution taken in the meeting of the ex officio governors, the respondent defend numbers 1 and 2, held on 18 June 2019, and constitution of the Board of Acting Governors of the school made on 21st June 2019. Further to that resolution, allegation is that on that date, the appellant plaintiffs 1, 2, 3, and 4 were removed from the board, and the respondent numbers defend numbers 3, 4, 5, 6 were appointed as acting governors in the board by the respondent defend numbers 1 and 2 by not noticing the ex officio members and excluding them from the meeting. The meeting was a nullity, so the decision taken therein such and such. This is denied by Mr. Shoknikant Mukherjee. Then, my lord, page 459, second paragraph. Prima facie, it appears that although this convention is not quite in accordance with the will come deed of endowment, other documents and decrees or orders of the court for running the school, but it nevertheless has been followed for quite some time. And then your lordship sees, my lord, towards the end of page 459, about the third last paragraph, at this stage, there is no evidence before us to declare the decision taken on 18th and 21st June as illegal or wrongful, but certainly they are under challenge and there are substantial grounds to challenge the same prima facie. We are of the prima facie opinion that there are 2 warring groups to take control of the administration of the school. We think the students should not suffer, the school has to run, its functioning cannot be frozen. Considering the fact that there is a substantial question to be tried and also taking into account the prima facie case and the balance of convenience, we appoint Justice Tapan Kumar Datto, a retired judge of this court and a former student of that school, as administrator. Board appointed on 21st June 2019, including the permanent ex officio governors, shall act under the control and supervision of the administrator. Well, this was the, my lord, order that was made. Ultimately, my lord, the administrator did not want to, my lord, function. But against this, my lord, there was a challenge brought, my lord, before the Supreme Court by the bishop. This order was challenged by the bishop before the Supreme Court, that your lordships will find at page 461. They filed the appeal. Then, well, when the Supreme Court makes some certain adverse observations, well, they withdraw the appeal. Well, this is the order. After hearing the learned counsel for the parties, learned senior counsel petitioners on instruction states that the appeal preferred by the petitioners before the division bench against the order of the learned single judge itself be treated as withdrawn. So, my lord, the appeal preferred by them before Justice I.P. Mukherjee was treated as withdrawn.
Justice Sinha's order.
Yes. We accept the request. The appeal of the petitioners before the division bench is thus dismissed as withdrawn, and consequently, any interim arrangement made thereto shall stand dissolved. So, my lord, the administrator goes. My lord, Justice Tapan Kumar Datta, my lord, goes. So, my lord, they make this concession before the Supreme Court and get rid of the administrator. Interim arrangement opined by the learned single judge in its order of 12 July 2019 stands restored, noticing that it is in the nature of a peremptory order. Then, my lord, after this, my lord, again the matter goes back before Justice Sinha. Now, my lord, there is a development here. If your lordships now see, my lord, page 483. Earlier order passed by Justice Arindam Sinha was an ad interim order. Now, my lord, the matter comes up again. Now, my lord, the contention is that, look, at the time when the earlier order was passed, the term or the tenure of the plaintiffs was still there. The period of 1 year had not elapsed. Now the period has elapsed, so get rid of this order. It is on that submission that, my lord, this order of 18th August 2020 is made. That's at page 483. Please come straight away to page 485, last paragraph. It is clear that the plaintiffs were appointed as additional governors for a period of 1 year. On approaching court, the interim order was passed and short directions given for expeditious adjudication and management being restored to the board. It is now therefore necessary that there be clarification that the interim order was not intended to overrun into the next term. Since the application could not be disposed of within the term of the plaintiffs on the controversy of whether they were rightly or wrongly removed, this clarification that the interim order cannot and does not presently operate. Mr. Shah submits that there was another aspect which led to the passing of the order of clarification should not be made. Other aspect is that the question of administration. Court, having had prima facie satisfaction on there being necessity in the matter of administration, had passed the interim order. It should not now be clarified to the effect of it being vacated. Court has perused the order of 12 July 2019 and is convinced that what weighed in the matter in the making of it was prima facie appreciation of the matter in which the of the manner in which the plaintiffs had been removed. Larger question of administration may be question to be answered, but not gone into at that stage. So, my lord, that order is, my lord, really vacated. Well, against that again, well, there is an appeal preferred. Well, that your lordships will now find at page 487. Well, this is really where the matter receives attention on merits. Page 487.
Yes.
My lord, here, my lord, the division bench, of which my lord Justice Banerjee, my lord, was a part, my lord, notices at page 488, the matter is of some importance and the slippery technical
Sorry
arguments.
to just a lighter note. I'm extremely worried. You know why? Can't remember a thing.
I can assure your lordships is not alone in this regard. Well, I must mention, my lord, many years back, I must say it must be at least 10 to 15 years back, I was at the chamber of Mr. Anindam Kumar Mitra. And he was suddenly lamenting that I don't know what has happened. I can't remember anything after 3 months. I was sitting there and wondering, I can't remember what happened this morning.
Yes.
The matter is of some importance and the slippery technical arguments made on behalf of some of the respondents would have the court miss the wood for the trees. The appeal arises out of an interlocutory order of 18th August 2020 passed in a suit pertaining to certain grievances in the management and administration of La Martiniere School, Calcutta. One of the reliefs claimed in the suit is for scheme of management or administration to be put in place. There is a bit of history which cannot be overlooked before addressing the present list. There is an old equity suit pending for nearly 200 years pertaining to the will of Claude Martin and the school set up as a consequence thereof. There is no dispute that a decree was passed in the year 1944 by this court framing a constitution for the school. 12 ex officio governors were to constitute the board of governors of the school. The posts were indicated as follows. These 12 posts are mentioned. However, the immediate succeeding clause in the decree dealing with the constitution of the board of governors of the school provided that no person officiating in the aforesaid offices who did not profess the Christian religion would be eligible to exercise or perform any of the duties as ex officio governor. It must also be noted that the 12 ex officio governors were empowered by the decree of 1944 to co-opt. Yes. Must also be noticed that the 12 ex officio governors were empowered by the decree of 1944 to co-opt 4 additional governors every year for the 16-member board of governors to run and administer the school. It appears that the constitution of the school as framed in 1944 decree has not been amended, nor does it appear that any meaningful attempt for the purpose of amending the same has been made. The decree and the constitution indicated therein are quite anachronistic. The country has gained independence, the state is now West Bengal, and even Calcutta of old is spelled differently. It appears that upon the first 2 named in the board of ex officio governors for long, not being persons professing the Christian religion, the 3rd named in the list has taken it upon himself to assume the post of chairman of the board of governors and wield powers the constitution may not have provided for the occupant of the relevant post. Further, since several of the other positions are no longer manned by persons professing the Christian religion, the board of governors has effectively shrunk to 2 or 3, with the successor in office to the Lord Bishop of Calcutta and the nominee of St. Andrew's Church of Scotland in Calcutta being the principal persons in control of the board of governors. Prima facie, it does not appear that the 1944 decree intended only 2 persons to control the board of governors. If it is necessary to respect the will of the founder, Claude Martin, that the permanent board of governors should not have non-Christian members, the decree could have been modified as the old equity suit remains pending and the perpetual overall mandate of this court continues. As far as the present suit is concerned, it was instituted by 4 persons who had been co-opted on the board of governors for a 1-year term and whose nomination was subsequently sought to be revoked. While it is true, as some of the respondents suggest, that personal reliefs qua the individual plaintiffs figure most prominently in the suit, there is a prayer for a scheme of administration or management to be framed, and it cannot be missed that the Board of Governors as functioning in the recent past may not be in consonance with the decree of 1944. The respondents suggest that the scope of the appeal is limited and that the interim order of July 12, 2019 was merely vacated by the impugned order of August 18, 2020, upon the court noticing that the 1-year tenure of the 4 plaintiffs would have run out in the usual course. However, it cannot be missed that the Board of Governors of La Martiniere is not the board in accordance with the decree of 1944. The appellants complain that major policy decisions have been taken by the Board of Governors headed by the present Bishop of Calcutta for establishing branches or new schools in the name of La Martiniere in conjunction with other schools. It would be in the best interest of all concerned that all decisions taken by the board after the institution of the suit or after the passing of the initial order therein on July 12, 2019 be not immediately given effect to except those pertaining to the day-to-day administration and functioning of La Martiniere School, Calcutta, both the boys and the girls section. No decision pertaining to any new school should be given effect to or any steps taken in pursuance thereof till the matter is decided. It may be necessary to make the constitutional document more contemporary and to revisit the manner of the composition of the Board of Governors of the school. Since such part of the exercise may be purely for the interest of the school and not adverse to any person, the exercise may even be taken up in the course of the present appeal to preserve and protect the interests of the school, which ought to be the paramount concern of the court. Appeal and the application therein will now appear a week after the court reconvenes following the puja vacations. It will be open to all the respondents to file affidavits, particularly to indicate how the new constitution of the Board of Governors of the school should be made. Since the your nominee plaintiffs would, in any event, have demitted office after the period of 1 year ran out, such plaintiffs cannot be restored to the position apparently occupied at the time of institution of the suit. For the moment, the current Board of Governors will continue to function, but it will not take any major decision or precipitous action except for the immediate purpose of the proper management of the girls and boys sections of the school in Calcutta. Urgent certified copies, etc. Now, my lord, this my lord, order was again, my lord, challenged, my lord, in a special leave petition that your lordships will find at page 493. The order at page 493 Appeal is still pending before the division bench. It appears that at the preliminary hearing, the contours of the dispute have been set out only to facilitate the respondents to respond to the same. This does not take away in any manner the right of the petitioner to contend that such issues need not be decided in appeal. As an abundant caution, we may state that any observations made in the impugned order naturally would not color the final finding in the appeal. And with that, my lord, the special lift petition was disposed of. Now, my lord, this matter thereafter, my lord, since the appeal was pending, the appeal ultimately came up before, my lord, the division bench of Justice Boshak. And, my lord, here the matter was argued out threadbare, including the question of, my lord, grant of leave under Section 92, revocation of leave under Section 92, my lord, Order 1, Rule 8, and everything else. Because my learned friends filed, my lord, application after application after application through several defendants on the same point. Leave under Section 92 needs to be revoked. Order 1, Rule 10 needs to be revoked. Or Order 1, Rule 8. Well, please have a look at this, my lord, judgment. This I shall, my lord, place in its entirety, because, my lord, this ultimately dwells on the entire matter on merits. All that, my lord, the division bench said after, my lord, going through the entire gamut of the matter on merits is that, look, your prayer before the learned single judge was limited to the question of your removal from the, my lord, board as additional governors. So, although I'm making these observations, I will not pass the order. Propriety demands that you go back before the single judge and ask for these reliefs. But, my lord, the entire discussion on merits is made in details here. Page 496.
This is the same appeal which Justice Shunji Banerjee
yes.
had admitted. So nothing happened to the scheme.
No
scheme, nothing.
Because, my lord, well, ultimately, my lord, proposals were sought. My lord, no proposals, my lord, were put forward on behalf of the school or on behalf of, my lord, the existing ex officio governors. We had given proposals which ultimately, my lord, both, my lord, the plaintiffs and, my lord, the, my lord, Alumni Association, my lord, who had sought to be added and was added as a party to the appeal, had given proposals. But ultimately, the school, my lord, did not respond.
495. 495.
Page 495. Lord, please see that first again point, and well, throughout this has been the only point. Maintainability, Section 92, Order 1, Rule 8. Well, Lord, please see paragraph 2. Respondent numbers 1 and 2 in the appeal have questioned the maintainability of the appeal by way of an interim application being such and such. An application being such and such has been filed seeking permission for the court to address on virtual platform, etc. Then 3, since an issue of maintainability of the appeal has been raised at the behest of the respondent numbers 1 and 2, they were allowed to address the court first. Huh? Yes, my lord, paragraph 2 at the end, your lordship will find that GA7 was also filed for framing of a scheme for management and administration. That, my lord, we had filed in the appeal subsequently. But since the issue of maintainability of the appeal had been raised at the behest of the respondent numbers 1 and 2, they were allowed to address the court. Respondent number 7 has supported the respondent numbers 1 and 2 in the appeal, and they were heard immediately after the respondent numbers 1 and 2. Thereafter, appellant, respondent number 8, respondent number 10 addressed court. All the parties had addressed the court on the point of maintainability. So, my the school, the bishop, the, my lord, presbyter of the St. Andrew's Church, and the additional governors appointed by them, and the secretary of the school, all, my lord, adopted the same stand. Paragraph 4 at 497, advocate appearing for the respondent numbers 1 and 2 has submitted that the suit filed by the plaintiffs primarily challenged wrong termination of the 4 plaintiffs, and the challenge the appointment of the defendant numbers 3 to 6. Plaintiffs had also prayed for framing a scheme for the administration of the institution run by the Public Charitable Trust. He has pointed out that an ad interim order dated 12 July 2019 was passed by the learned trial judge, restraining the Board of Governors of the school not to take any decision regarding the management of the school till disposal of the interim application. The ex officio governors had been restrained from appointing any additional governors. Appeal Court had, by an order dated 25th July 2019, appointed administrator of the Board of ex officio governors. 2 sets of appeal had been filed before the Honorable Supreme Court. Such appeals before the Honorable Supreme Court had been withdrawn, as it was agreed that the interim arrangement put in place by the order of 12 July 2019 stood restored. Application for effecting the order of 12 July 2019 has been made, in which an order dated 19th August 2020 was passed. Trial court had observed that by the impugned order dated 18th August 2020, that the order of 12 July 2019 needs to be clarified. Order dated 12 July 2019 was not intended to overrun into the next term. In the appeal from the order dated 20th August 2020, the appeal court passed an interim order dated 8th October 2020, which was clarified by the Honorable Supreme Court. Honorable Supreme Court had observed by the order dated 27th November 2020 that the order dated 8th October 2020 sets out the contours of the disputes and that it did not take away the right of the defendants to contend that such issues need not be decided in the appeal. Advocate for the respondent numbers 1 and 2 had submitted that the application being GA 1517, in which the initial order of injunction of 12 July 2019 was passed, does not contain any prayer inviting the court to frame any interim scheme of management. In any event, formulation or modification of the existing scheme, if at all, is required to be made, if at all the same is required to be made, should be decided at the final hearing of the suit. The parties have to be given an opportunity to lead evidence with regard to such an issue. At the final hearing, the court has to examine as to whether there was breach of trust as claimed or whether the plaintiffs were not suing to vindicate their personal or individual rights or whether there was any case of breach of trust made out. In support of such contentions, he has relied upon, whether these judgments are relied upon, to say that the suit is not maintainable under Section 92. Advocate appearing for the respondent numbers 1 and 2 has submitted that the suit was filed after obtaining leave under Section 92 of the Code of Civil Procedure. Leave had been obtained ex parte. Leave under Section 92 of the Code of Civil Procedure had been revoked subsequently. Against such order of revocation, an appeal had been preferred. Appeal court had observed that the maintainability of the civil suit is required to be decided as a preliminary issue. He relied upon such and such in support of his contention that till the time the issue of leave is decided, court should not exercise any power under Section 92 of the Code. Learned advocate appearing for the respondent numbers 1 and 2 has submitted that there was no pleading in the plaint warranting the court to frame a scheme. Moreover, the schools concerned are minority institutions. Management and administration of a minority institution is within the exclusive domain and fundamental right of the institution. There is no allegation of mismanagement affecting the interests of students. No ground under Section 92 of the Code of Civil Procedure has been made out in the plaint. Advocate appearing for the respondent numbers 1 and 2 has submitted that the will of late Major General Claude Martin provides for setting up of educational institution by the Supreme Court. Article 24 of the will of late Major General Claude Martin has given the name of the school and makes provisions for children of Christian community of any class to be taken care of by the school. Supreme Court, by its decree of 22nd October 1832, had constituted the school. He has drawn the attention of the court to the contents of the decree dated 22nd October 1832 and submitted that directions for appointment of ex officio governors, additional governors, and secretary for the purpose of management of the school were given. Decree has also directed the school to recruit students amongst Christian population of Kolkata and every children of Christian community to receive education upon payment of fees. He has referred to order dated 6 June 1944, which was passed on the petition of the then Advocate General of Bengal, where it was expressly provided that no person other than Christian can be appointed as governors. Learned advocate appearing for the respondent numbers 1 and 2 and has contended that the decree as well as the constitution establishes that no person other than a Christian is eligible to be appointed as an ex officio governor of the school. He has interpreted the clause for the time being in the order dated 6 June 1944 to mean that if the office of the ex officio governor is not occupied by a person professing Christian religion, he cannot be appointed and other ex officio governors will take that position. Learned advocate appearing for the respondent numbers 1 and 2 has submitted that there were attempts earlier to interpret the decree and the constitution to mean that non-Christian can be appointed as ex officio governors and that such attempts failed. In this regard, he has referred to orders dated February 1, 1968, order dated 12 July 1966, and the order of 1st March 2000, passed by the division bench. Relying upon such and such, learned advocate appearing for the respondent numbers 1 and 2 has contended that since the school is a minority institution, it is not permissible for the court to interfere in its administration. Respondent number 7 has supported the
Who is the respondent number 7?
He is the secretary of the school. Respondent number 7 has supported the contentions raised by the respondent numbers 1 and 2. Learned advocate appearing for the respondent number 7 has contended that the court should not interfere in the management of a minority institution. In addition to the authorities relied upon by the respondent numbers 1 and 2, learned advocate appearing has relied on further judgments. With regard to the quorum specified in the modified decree, learned advocate for the respondent number 7 has contended that such quorum is limited to the valid eligible members, and since only 2 of the 12 ex officio members profess Christian faith, the quorum should be calculated from amongst these 2 members. Advocate appearing for the respondent 2 has relied upon Aurobindo Ashram, in support of the contention that the plaintiffs cannot seek vindication of personal or private rights in a suit under Section 92 of the Civil Procedure Code. Relying upon, well, again, a number of judgments is cited, advocate for the respondent number 7 has contended that no relief should be granted beyond the pleadings. He has relied upon Oyon Chatterjee versus Future Technology to contend that a suit is required to be decided on the basis of pleadings and evidence adduced and not by way of interlocutory application. Advocate appearing for the respondent number 7 has submitted that the plaintiffs obtained benefit of being appointed as members of the Board of Governors. Having obtained such benefits, they cannot challenge the same instrument by virtue of which they are benefited. Then, my lord, decisions are again referred to. Advocate appearing for the respondent number 7 has drawn the attention of the court to the earlier orders passed by the High Court in the 2 previous proceedings and submitted that the appellants are not entitled to any reliefs. Learned senior advocate appearing for the appellants has submitted that 2 schools for one for the boys and one for the girls were established as a public charitable institution under the will of Major General Claude Martin. He has drawn the attention of the contents of the will and contended that pursuant to the charitable objects, the schools were established by the Supreme Court of Judicature at Fort William in Bengal in Old Equity Suit of 1832. Honorable Court has inherited the Old Equity Suit in which the decree of 1832 was passed, and as such is the guardian of the schools at Kolkata and consequently exercises parents' patrie jurisdiction over the 2 schools. Well, then decisions were referred to in support of this proposition. Advocate appearing for the appellants has submitted the courts have a parents' patrie jurisdiction over the trusts for charitable and religious purposes and can always act in public interest in respect thereof. Advocate appearing for the appellants has submitted that the decree of 22nd October 1832 as modified on 6 June 1944 provided that school must be administered by a board of 12 ex officio governors, which would in turn be entitled to appoint 4 additional governors every year. Admittedly, according to him, most of these ex officio posts have ceased to exist since such ex officio posts are manned by persons who are not Christian. As a result, it is only the Bishop of Kolkata and the Minister of St. Andrew's Church in Kolkata which are now running the schools. The Minister of St. Andrew's Church in Kolkata is nominated by the Bishop of Kolkata, and as such, the school is essentially being run by way of one ex officio governor, that is the Bishop of Kolkata. Advocate appearing for the appellants has submitted that the constitution of the Lamartine School at Kolkata makes it clear, while it refers to the Board of Governors, that it is a composition of 12 ex officio governors and the 4 additional governors to be elected only in terms thereof, and are collectively referred to as the Board of Acting Governors. He has referred to Article 7 of the Constitution, which provides for the quorum. According to him, the present Board of Governors has been acting and is continuing to act without a quorum. All decisions of the Board of Governors without the requisite quorum of at least 4 ex officio governors have been and are illegal and wrongful. That by itself, according to him, has constituted the breach of the express trust created by the decree of 1832 as modified in 1944, for which Section 92 of the Code of Civil Procedure can be invoked. He has contended that this Honorable Court is entitled to and should settle a scheme of the trusts, particularly when the whole scheme is no longer workable, and grant such relief as required. Advocate for the appellants has contended that the opposition of the respondent numbers 1 and 2 on one post and the respondent number 7 on the other, on one part it should be, on the other, are strange. He has contended that such respondents did not explain why the scheme should not be molded to ensure participation of 12 ex officio governors for the administration of the school. Opposition of such respondents has shown that they were interested only in perpetuating the wrongful control over the schools. Advocate appearing for the appellants has referred to the pleadings of the plaintiff and have submitted that the first paragraph, along with various other pleadings of the plaintiff, establishes that the suit was under Section 92 of the Code. He has distinguished the authorities cited on behalf of respondents 1, 2, and 7 with regard to maintainability. Advocate has relied upon then several decisions reported in support of the contention that an interim relief can be granted pending decision of a preliminary issue at the trial of the suit. Advocate appearing for the appellant has submitted that the division bench in the appeal have passed an order on 8 October 2020 observing that it is necessary to revisit the composition of the Board of Governors of the school. The division bench had directed all the respondents to indicate how the new constitution of the Board of Governors of the school should be made. An appeal had been preferred against such order, which was disposed of by the Honorable Supreme Court by its order dated 27th November 2020, without interfering with the order dated 8th October 2020. Advocate appearing for the appellants has contended that the schools were not established as minority institutions. He has contended that neither the will of Major General Claude Martin nor the decree dated 22nd October 1832 specify that the school was to be administered by the Christians only. The decree had been modified on 6 June 1944, which provided that ex officio governors of the school must profess the Christian faith. The school has obtained a minority certificate in the year 2010, which does not, however, show that the same is a religion-based minority institution. Advocate appearing for the appellants has submitted that the modified decree dated 6 June 1944 provided that ex officio governors would be of Christian faith for the time being. He had submitted that the court has retained the jurisdiction to modify the decree from time to time as the occasion arises. Since out of the 12 ex officio members to the Board of Governors, most are no longer Christians, particularly in view of the quorum provided by the Constitution, it would be appropriate that some valid ex officio Board of Governors, some arrangement was made for the purpose of constitution of a valid ex officio Board of Governors of the school. Referring to the order dated 1st February 1968 and the order dated 1st March 2001 by a revision bench, latter of which was passed in a suit questioning the acts of the Board of Governors in leasing out a portion of the school ground, learned advocate appearing for the appellants has contended that such order did not take into account the fact that the Board of Governors were without a quorum. In any event, the same was an interlocutory order. Advocate appearing for the respondent number 8 has supported the contentions of the appellant. He has submitted that his client is an ex-student of the school and is a beneficiary under the will of Major General Claude Martin. He has referred to the will of Major General Claude Martin and contended that late Major General Claude Martin was an army man and not a missionary. Though born as a Roman Catholic, he had respected all religions. He had desired to do charity for people of all faith. Apart from other bequests for other charitable works mentioned in the will, a bequest was made to the town of Kolkata under the protection of the government or the Supreme Court to devise an institution most necessary for public good or establishing a school to be named La Martiniere. As Major General Claude Martin was unable to establish a management for the institution, he had hoped that the government of the government or the Supreme Court would devise the best institution for a public good as per his desire. Advocate for the respondent number 8 has contended that the intention of the founder was not to sponsor a missionary school or to have a school exclusively for the benefit of Christians or to be run exclusively by them. On the contrary, Major General Claude Martin had envisaged a school for the public good for the town of Kolkata, and it was to be under the protection of the government or the Supreme Court without any restrictions on the religion of managers. Senior advocate appearing for the respondent number 8 has referred to the decree dated October 22, 1832 and contended that the intention of the settlor was retained and the composition of the Board of Governors was secular and not restricted to Christians alone. Further, the court had retained full authority to alter the scheme for better management and administration. He has submitted that the decree dated 23rd May 1946 amended the decree dated 22nd October 1832. He has contended that the power and authority of the court to appeal the scheme for better management in the school continues to remain. Should be to apply the scheme.
Amend.
Yes, amend. Then the advocate appearing for the respondent number 8 has contended that the judgment in order dated February 1, 1968 does not change the position with regard to the composition of the Board of Directors. He has contended that such judgment in order is not an authority for the proposition that the nature of the school cannot be changed. In fact, it has held that the additional governors can be non-Christians and left the issue with regard to modification of the management of the school at the final hearing of the suit. Advocate appearing for the respondent number 8 has referred to the judgment on order dated 12 July 1996 and 1st March 2000 passed in the old equity suit and contended that the observation by the division bench with regard to Christian character of the school was without jurisdiction. In support of such contention is relied upon, there's a judgment of the Supreme Court here. He has contended that supervening circumstances justify the alteration of the scheme and that the bar of res judicata will not apply. In support of such contention, he is relied on, well, again, a decision has been referred to. Emphasizing upon the necessity for the court to intervene, senior advocate for the respondent number 8 has contended that changed circumstances have created a vacuum in the Board of Governors of the school. Out of the 12 ex officio members to the Board of Governors, only 2 are occupied. This has resulted in a requisite quorum to be absent. These 2 ex officio governors who do not constitute the quorum are holding meetings and are appointing additional governors and removing the same at their whim, which they are not entitled to. None of the respondent numbers 1 and 2 are eligible to be ex officio members of the Board of Governors. Presently, the Board of ex officio Board of Governors of the school are comprised of the Church of North India nominees who are neither independent nor a representative body of 12 eminent persons from different fields, as has been contemplated by the founder of the school. Relying upon, again, decisions, advocate appearing for the respondent number 8 has contended that the court retained the power to pass necessary orders. In view of the court being guardian of the school and the suit being in respect of public trust, it was the duty of the court to safeguard the beneficiary and act for the benefit of the trust. Relying on again, my lord, the judgment of the Supreme Court, learned advocate appearing for the respondent number 1 has contended that the objections with regard to jurisdiction do not prevent the court from passing interim orders. Advocate appearing for the respondent number 10 has submitted that even though the appeal was against the order of 18th August 2020, the appeal court has passed to grant relief sought for in the appeal.
This 10 was the alumni.
10 was the, yes. The court can mold the relief considering the change of circumstances to do complete justice. In support, my lord, again, decisions are relied upon. He has referred to the provisions of Order 41, Rule 33 of the Code of Civil Procedure for the proposition that the court can grant such relief. Advocate appearing for the respondent number 10 has submitted that interlocutory application being such and such was being considered along with GA 1532. Such application had the necessary pleadings to grant reliefs regarding the mismanagement of the schools. He has contended that in the event this Honorable Court refuses to pass any order, despite considering the complete failure of the present scheme, serious prejudice would be caused to the students of the school. Honorable Court then would be condoning and perpetuating express illegality of the Board of Governors. 2 division benches had passed orders for constitution of Board of Governors. He has contended that in the absence of specific prayer for devising a scheme does not prevent the court from exercising its inherent powers. Then a judgment of Andhra Pradesh High Court was referred to. Advocate for the respondent number 10 had submitted that the court has jurisdiction and power to regulate and modify the scheme of management of the schools. He has contended that the order dated 1st March 2020 passed in the old equity suit does not operate as res judicata. The existing scheme of management is archaic and not workable. The contention of the respondent numbers 1, 2, and 7 that the school should not interfere, that the court should not interfere with the scheme is fallacious. The judgments relied upon by the respondent numbers 1, 2, and 7 are not applicable to the facts of the present case. Appeal has arisen out of an order dated 18th August 2020 passed by the learned trial judge in an interlocutory application of the plaintiffs. The appellants as plaintiffs had filed a suit alleging mismanagement in the administration of 2 schools and claiming reliefs relating to appointments to the additional board of governors of the 2 schools and framing a scheme for the administration and management of the 2 schools. Late Major General Claude Martin had left behind a will dated 11 January 1800, where he had bequeathed various assets for the purpose inter alia of setting up of 2 schools in Kolkata. Clause 24 of such will has relevance and the same is as follows. I give and bequeath the sum of 200,000 Sikka rupees to the town of Calcutta for to be put an interest in government papers or the most secure mode possible, and this principal interest to be put under the protection of the government or the Supreme Court, that they may devise an institution the most necessary for the public good of the town of Calcutta, or establishing a school for education for to educate a certain number of children of any sex to a certain age, and to have them put apprentice to some profession at the conclusion of their school, and to have them married when at age. And I also wish that every year a premium of few rupees or other thing and a medal be given to the most deserving of virtuous boy or girl, to such that they have come out of that school or that are still in it, and this is to be done on the same day in the month died, that day, etc., married to be church. Then, my lord, these are not really important. My lord, what is important is, my lord, there's no mention of religion here. Then please see paragraph 39. Supreme Court of Judicature at Calcutta had dealt with the will of late Major General Claude Martin in old equity suit. Supreme Court of Judicature at Calcutta had passed a decree dated October 22, 1832, directing inter alia, number 1, a school called and distinguished by the name of La Martiniere be established. The following persons, their consent having been first obtained, shall be ex officio governors of school, namely A, the Governor General, B, the members of Council of Judges of the Supreme Court, C, the Bishop of Calcutta, D, Advocate General. Provided always that if any of such persons shall not consent to become a governor of the school, an application shall be made to the Supreme Court to appoint some other person in view of every person so refusing. The ex officio governors had been empowered to annually elect and nominate 4 additional governors, who shall during the year for which they shall be so nominated and elected have equal power and authority with the ex officio governors of the school in the management and direction thereof, and in all matters relating thereto. There shall be a paid secretary who shall be nominated and appointed by the governors of the school. In terms of the decree dated October 22, 1832, the Advocate General of Bengal had applied for amendment of such decree, which was allowed by a decree dated 23rd May 1940, should be 4. 6 June. No, what is the date? 23rd May 1946? That date is wrong.
Yes, wrong.
Well, it should be 1944, my lord. There's a mistake here. The amendment to the decree dated 22nd October 1832 had been made by its Honorable Court in the old equity suit. By the amendment, the Viceroy and the Governor General of India was made the visitor of the school. It had been directed that there shall be 12 ex officio governors in substitution for the Board of Governors appointed by the decree dated 22nd October 1832 being, well, the 12 posts are mentioned thereafter. Provided always that no person for the time being holding or officiating in any of such offices who does not profess the Christian religion shall exercise or perform the powers or duties of an ex officio governor. In respect of the affairs of the school, a suit being suit number 2602 of 1967 had been filed in this Honorable Court, where an interlocutory order dated 1st February 1968 was passed. This court has been informed that such suit was struck off from the register of the suits in 1969. The judgment and order dated 1st February 1968 therefore has lost significance in view of the suit in which it was passed no longer remaining. Now, Malad, this, Malad, is what the division bench had held, but this suit apparently... This is Krishna is pending. Malad, apparently the learned single judge has, Malad, made inquiries and found that this suit is still pending. Malad, this is, Malad, really the point which is weighed with the learned single judge. And my lord, his lordship was the opinion that this, my lord, factum of pendency of this suit has been suppressed. So, my lord, it is disentitled the story. I shall show your lordship what are the orders in the suit later, once I place this. The then existing Board of Governors had applied to the High Court in the old equity suit seeking sanction of this court to enter into an agreement for development of a portion of the land situated at the boys' school in order to augment the income for better administration and management of the school. Such applications had been disposed of by a judgment and order dated 12 July 1996. The court had noticed the composition of the Board of Governors as stipulated by the decree of 23rd May 1946 and observed that the most of the posts were non-existent. The court had reworked the composition of the Board of Governors of the school. An appeal had been carried from such judgment and order dated 12 July 1996. Appellate court had, by the judgment and order dated 1st March 2000, set aside the direction of reworking of the Board of Governors and appointment of new Board of Governors. The court had retained the jurisdiction to pass orders in the old equity suit while passing the initial decree and the amendment thereof. Jurisdiction of this court had been invoked earlier in the old equity suit relating to the management and affairs of the two schools. Independent of the pendency of the old equity suit, approach had been made to this Honorable Court relating to the management and administration of the two schools in 1967 by way of a suit, which suit was subsequently struck off the register. My lord, this apparently, my lord, according to the learned single judge, is not correct. In the present suit, the plaintiffs have obtained leave under Section 92 of the Code of Civil Procedure 1908, ex parte. Such leave had been revoked. On appeal from the order revoking the leave, the appellate court had directed that the issue of maintainability of the suit under Section 92 of the Code of Civil Procedure would be decided at the trial of the suit. This court has been informed that although the writ of summons had been served upon the defendants, they did not file written statement. The suit has not been set down for trial. Issue of Section 92 of the Code of Civil Procedure yet to be finally decided. My lord, very important that, my lord, no written statement has filed in the suit yet. Then referring to, my lord, Paramatmanand Saraswati has held that even if all other ingredients of a suit under Section 92 of the Code of Civil Procedure are made out, if it is clear that the plaintiffs are not suing to vindicate the right of the public, but are seeking a declaration of the individual or personal rights or the individual or personal rights of any other person or persons in whom they are interested, then the suit would be outside the scope of Section 92. Paramatmanand Saraswati has noted Vidyodaya Trust, and in the facts of that case, the suit was found to be not maintainable as the same was for settling private or personal dispute. The above two authorities have been noted in Aurobindo Ashram Trust, and it was held that the suit was not maintainable in the facts of that case. Satyanath had set aside an order directing framing of a preliminary issue with regard to the plea of res judicata and directed all the issues to be heard and decided by the trial court. Ahmed Adam Said and others, the Supreme Court, while dealing with the suit instituted under Section 92 of the Code of Civil Procedure, observed that even after a scheme was framed for a suit property instituted under Section 92, if supervening consideration justified its alteration or modification, the bar of res judicata cannot be pleaded against such alteration or modification. It is held that a subsequent suit under Section 92 of the Code, despite an earlier suit under such provisions being decreed, was still maintainable. Well, this is a very important dictum of the Supreme Court, which perhaps has escaped the attention of the learned single judge. a subsequent suit is still maintainable under Section 92. In Vikram Das Mahant has considered the issue whether the decree in an earlier Section 92 suit entitles the plaintiff thereon to sue. It was held that where public trusts are concerned, courts have a duty to see that their interests and interests of those for whose benefit the trust exists are safeguarded. Therefore, courts possess power to sustain proper proceedings and grant relief in the interests of and for the express benefit of the trust, imposing such conditions as may be called for. As has been noted above, the issue with regard to Section 92 of the Code is yet to be finally decided in the suit. Therefore, it would be premature to say that the suit is essentially one for the purpose of vindicating individual or personal rights. The contentions of the respondent numbers 1, 2, and 7 are not in the realm of an Order 7 Rule 11 scenario with regard to Section 92 of the Code. In any event, a subsequent suit under Section 92 of the Code is maintainable if the facts justify it. The appellants as plaintiffs had applied for interim release before the learned trial judge. The interlocutory application of the appellants before the trial court has revolved around offices held by the appellants and with regard to appointment of additional Board of Governors, without praying for any relief regarding the composition of Board of Governors by altering the existing scheme. As has been noted here and above, the issue of Section 92 of the Code of Civil Procedure is yet to be finally decided. The question, therefore, is whether pending decision of the maintainability of the suits can interim release be granted to the plaintiffs. In TK Lathika, the Supreme Court has considered a bar under Kerala Building Lease Rent Control Act on a transferee landlord from filing a suit of eviction within 1 year of the transfer. In such context, it is held that the issue of maintainability of the suit needs to be decided first before any relief being granted. In Ramanarang, Supreme Court has noticed such and held that the objection of jurisdiction is taken. The court should decide such question first. However, that does not mean that pending the decision on the question of jurisdiction, the court has no jurisdiction to pass interim orders, as may be called for in the facts and circumstances of the case. Mere objection to jurisdiction does not instantly disable the court from passing an interim order. It can pass appropriate orders. In Ramesh Desai, the Supreme Court has held that the question of limitation is a mixed question of law and fact. Code of Civil Procedure confers no jurisdiction to court to decide a mixed question of law and fact as a preliminary issue unless the facts are clear from the plaint itself, and the mixed question of fact and law can be determined on principles of demurrer. Provisions of Order 41, Rule 32 of the Code of Civil Procedure have been considered in Jayaprakash Gupta and Gaivdin Choi Rani, where it has been held that appellate court has power to grant reliefs, taking into consideration the subsequent events having direct bearing on the reliefs claimed or on the entire purpose of the suit. In the facts of the present case, the basis of seeking reconstitution of the Board of Governors and framing of scheme is not on the subsequent events, but on events which had happened prior to the institution of the suit. In the Supreme Court in Aryan Goshai had held that a party to a proceedings after electing to accept a transaction as valid and taking advantage of such transaction cannot be permitted to challenge the validity of such transaction. In the facts of that case, the tenant filed an undertaking to vacate the premises. In the facts of that case, it was held that by furnishing the undertaking, the tenant had elected to avail the protection from eviction of the premises and enjoy such protection. Having so done, the tenant cannot be permitted to assail the order by which he availed the benefit. In Bhagwat Saran, the Supreme Court has observed as follows. Well, I shall not trouble your lordship with the citation. According to the respondent numbers 1, 2, and 7, appellants as plaintiffs having taken advantage of their respective appointments at Additional Board of Governors pursuant to the modified decree of 1944, they should not be allowed to challenge such decree on the ground that the appellants as plaintiffs cannot be allowed to approbate and reprobate. With respect, we are unable to agree with such contentions of the respondent numbers 1, 2, and 7. The appellants plaintiffs had been appointed additional governors pursuant to the decree dated 6 June 1944. The appellants as plaintiffs may not obtain any relief at the final hearing of the suit if it is held that their appointments were bad, but that does not preclude them to raise the issues with regard to the composition of the Board of Governors or the requirement to have the same by amending the decree. Appellants as plaintiffs having accepted their appointments from persons who are in wrongful control of a public trust does not denude the court from considering whether the public trust was in the control of persons who were directed to be in control thereof by a decree of court or not. In the facts of the present case, the court had retained the jurisdiction to look into and rework the composition of the Board of Governors, modify the scheme, and issue necessary directions with regard thereto if the occasion so arises. The jurisdiction of the court to look into the composition of the Board of Governors by virtue of individual actions of such certain plaintiffs in a suit cannot be ousted. The appeal is held to be maintainable. In the present suit, the issue as to whether the educational institutions concerned are minority educational institutions or not or whether their rights as minority educational institutions are sought to be affected does not arise. The court had passed a decree directing the composition of the board of directors and retained the jurisdiction to recompose the same. This jurisdiction of the court cannot be ousted on the plea that the institutions concerned are minority educational institutions. In any event, a minority educational institution cannot be held to be outside the judicial scrutiny of a court in a suit instituted under Section 92 of the Code of Civil Procedure. Plea of the institution being a minority institution does not affect the rights of the parties and the jurisdiction of the court under Section 92 of the Code. Consequently, the authorities cited at the bar in respect of minority rights need not be discussed at length. It is trite law, as has been observed by Ibrahimuddin, that relief not founded on pleadings cannot be granted. All material facts has to be pleaded, and the party cannot be allowed to travel beyond the pleadings. The other authority cited on the point, a party must not travel beyond the pleadings, and therefore all material facts has to be pleaded, are not discussed at length here. The learned trial judge had considered J number such and such while passing the order of 12th July 2019, which was subsequently clarified by the impugned order. The learned trial judge had noted the rival contentions of the parties while passing the order dated 12 July 2019. Learned trial judge had taken into consideration the contents of the will of late Major General Claude Martin. Learned trial judge had taken into consideration the letters dated 22nd March 2019 on election and nomination of the 4 additional governors. Learned trial judge had noted that such letters contained the signature of the then 2 ex officio governors. Learned trial judge had also taken into consideration letters dated 19 June 2019, which spoke about a meeting of the ex officio board of governors dated June 18, 2019. Learned trial judge had recorded the fact that the court perused the 2 documents bearing signature of the continuing ex officio governor. Learned trial judge had to note that persons who can officiate as ex officio governors have been described in the decree and the amendment order. Learned trial judge had recorded that one of such persons had signed 2 documents, contents of which contradict each other. Learned trial judge had refrained from making further comment. In such circumstance, the learned trial judge had returned a finding that the plaintiffs were entitled to an interim order. The learned trial judge had protected to grant interim order in favor of the plaintiffs or appellants. The interim order that had been granted was as follows. The Board of Governors of the school will not take any decision regarding management of the schools until disposal of the application. Ex officio governors will not in that time appoint any person as additional governors. Learned trial judge, after having been satisfied that a case for granting interim order was made out by the plaintiffs or appellants, had proceeded to clarify through the impugned order that such order was limited for a period of 1 year. In the facts and circumstances of the present case, it would be appropriate to hold that the pleadings of the appellants or the plaintiffs have made out a prima facie case. The balance of convenience and inconvenience was also in favor of the appellants or plaintiffs in granting interim reliefs. The interim order initially granted on 12 July 2019 had proceeded on the basis of a person who can officiate as ex officio governor, signing 2 documents, contexts of which contradict each other. The interim order granted was not in relation to the appointment of the plaintiffs or appellants as additional governors, but related to the management of administration of the affairs of the 2 schools. Management and administration of the 2 schools are not limited to the time period of the office of the plaintiffs or appellants, particularly in view of the fact that the suit was under Section 92 of the Code of Civil Procedure 1908. The plaintiffs' appellants have raised serious issues with regard to the composition of the Board of Governors of the 2 schools. Interests of the public, including the students studying in the 2 schools, have to be taken into consideration. Prima facie, there is an urgent need for the court to revisit the composition of the Board of Governors. As on date, there are only 2 members of the Board of Governors. The requisite quorum as prescribed by the constitution of the 2 schools are not available in the present Board of Governors of the 2 schools. Therefore, there is a serious issue as to whether the present Board of Governors can function at all without the requisite quorum being present. However, those issues have to be taken into consideration in an appropriate proceeding. The scope of the appeal being limited, we refrain ourselves from embarking on such route despite the order dated 8th October 2020. In such circumstances, it would be appropriate to direct the Board of Governors of the 2 schools will not take any decisions regarding the management of the 2 schools till disposal of the interlocutory applications. The ex officio governors will not, till the disposal of the interlocutory applications, appoint any person as additional governors. All decisions taken by the Board of Governors after the institutional suit or after the passing of the initial order therein on 12 July 2019 be not given effect to, except those pertaining to the day-to-day administration and functioning of the 2 schools. No decision pertaining to any new school should be given effect to, or any steps taken in pursuance thereof till the interlocutory applications are decided. Learned judge before whom the matters are pending is requested to dispose of, etc. Huh? Well, then, well, it's 74, APO 72. Yes. During the pendency of the appeal, an application being GA number 7 of 2023 has been filed seeking framing of a scheme for the management and administration of the two schools. In view of Meena Chaudhary, since the scope of GA 7 of 2023 is greater than the scope of the main appeal, such prayer is not considered by us. It would, however, not prevent the parties to the suit from seeking appropriate relief before the trial court. All points left open, etc. Now, my lord, in such circumstance, my lord, we went and filed, my lord, a similar application before the learned single judge for framing of the scheme. My lord, this, my lord, judgment and order of Justice Boshak was once again challenged before the Supreme Court. That your lordship will find at page 596. That's in volume, now it's volume 4. 96.
Same volume.
Upon hearing, counsel for the court made the following order. Counsel for the petitioner submits that the real issue is only the expression except those pertaining to the day-to-day administration and functioning of the two schools must take care to page 597. 596 it starts. Well, these were two special petitions. One is filed by the Malad Bishop and the other is by the Secretary. Well, the second paragraph of the order is relevant. After some arguments, learned senior counsel submits that he seeks to withdraw these petitions to move the High Court for any clarification. Special leave petition stands dismissed as withdrawn. And then, my lord, there was another order. My lord, this is in the next volume, volume 5. Another order of the Supreme Court at 653, volume 5.
All the applications were being filed. At this stage,
Well, this is a second special leave petition against the same order of Justice Boshak, and this is while the appeals and the applications are being heard, while the applications are being heard by the before the learned single judge. Now, well, this is filed through the additional governors, newly appointed additional governors, at page 654. We are not inclined to entertain the special leave petition. The special leave petition is dismissed accordingly. However, we clarify that while deciding the preliminary issue, the learned single judge would not be influenced by the observations made by the division bench in the impugned order. Now, my lord, what is the preliminary issue? That the suit is not maintainable, my lord, under section 92. My lord, thus far, my lord, from the orders and my lord, from the recordings made in the judgments, your lordships have found that the only defense taken is, my lord, number one, my lord, the well, on the merits of the matter, if I may look at it, it says that, my lord, ultimately, if you look at the constitutional school or the decree of 1944, it says if today these posts have ceased to exist, or if the persons, my lord, of Christian faith cannot be found for these posts, then whoever is available will be the Board of Governors. Well, with the greatest of respect, my lord, this is a little difficult to accept. That was never the intention of the scheme, and that is never the purpose of a trust. Now, if your lordship looks at, my lord, the purpose of the decree of 1944, my lord, pre-independence, my lord, the original decree, my lord, which established the school, did not say that only Christians. But a decree of 1944, which modified the original decree, provided for 12, my lord, ex officio governors of Christian faith. My lord, one can understand, my lord, that, my lord, the gentleman himself was a, my lord, practicing Roman Catholic. He sets up the school. My lord, the scheme is framed by, my lord, the English gentry, my lord, by an advocate general, my lord, who is an Englishman himself and provides, my lord, 12 will be of Christian faith. But, my lord, so far as that is concerned, that is where it says. It says for the time being. That is, my lord, what's expressly mentioned in the decree of 1944. I will show your lordships that for the time being. Now, my lord, at the end of the day, the only argument on merits, as it appears from, my lord, the recordings made in the orders of this honorable court, is that the scheme must be read and understood, and consequently the constitution of the school must be read and understood to mean that if no one is available, my lord, ultimately falling within the qualifications of, my lord, ex officio governors, then there need not be any ex officio governors at all. Or if one person is available, one is enough. Well, that is, my lord, what is the submission. Apart from that, submission is section 92 you can't invoke, because you had in fact filed the suit for vindication of personal grievance for having been removed as additional directors of the school. Well, these are, my lord, really the two essential submissions that have been made. The third submission was, this is a minority institution, the court should not interfere. Well, there, my lord, of course, my lord, the learned single judge says that no, it's ultimately at the end of the day a charitable trust. But it has been set up by the High Court. The High Court is therefore entitled to and has been exercising a parents' patry jurisdiction. Ultimately, the High Court has to ensure, even without the application of any person, because that is the language of section 92, that ultimately, my lord, the scheme is not flouted, the scheme is not disrupted, the scheme is not set at naught, and my lord, the scheme is ultimately carried into effect in the manner in which the scheme was devised. And that is why, my lord, the only reason why the division bench remanded the matter back to the learned single judge is saying that no, the scope of the appeal is limited, because the original order, my lord, that was passed was really an order which confined, my lord, was confined to the removal of the 4 additional directors. So I will not in the appeal, although the scope of Order 41 Rule 33, my lord, permits me to do so, or my lord, even the scheme of, my lord, section 92 permits me to do so, I shall not do so. I shall send it back to the learned single judge for passing this order. Now, my lord, we come back before the learned single judge. Again, the same arguments are repeated. Section 92, suit is barred. You cannot proceed with the suit. It's a question of maintainability. It has to be decided first. Now, the division bench had said that this has to be decided as a preliminary issue at the time of trial. A trial cannot commence till the written statements are filed. My learned friends have not filed written statements. Yet, my lord, they have been, my lord, vociferous in their attempt to say that section 92 could not have been invoked.
Writ of summons served.
Yes, yes. Writ of summons served. My lord, my learned friends are appearing. They are contesting in full measure, more than full measure, I should say. But, my lord, they have not come forward to file written statements. And, my lord, the second grievance that was raised was that, look, if you frame a scheme at this stage, you will be disposing of the suit itself. How can you do that at an interlocutory stage? To which we cited judgments, which very clearly says that, my lord, at times when the need of the hour so demands it, you can pass an ad interim order which may be in the nature of a final order. For example, my lord, in trademark matters, my lord, where there's an allegation of infringement of trademark and the final relief is a relief of injunction, restraining the infringer from infringing the mark, your lordships pass an order of injunction, which is final in all respects. My lord, there are many times where, my lord, for example, let us say that there is a, my lord, contract which has been wrongfully terminated. Your lordships come and stay the termination.
Demolition.
Demolition. Service in employment, my lord, jurisprudence, it is always done. So, my lord, it is not an universal rule. It is a matter of, my lord, more a matter of practice that, my lord, the court should endeavor not to pass final orders at the interlocutory stage. But that does not mean that ultimately the court will find itself shackled, my lord, by these, my lord, tenets of procedure from actually doing, my lord, substantial justice. And, my lord, that is now settled law. First point. Second point, my lord, the court can also proceed to consider, even when a question of maintainability is being raised, the question of jurisdiction is being raised, the court still retains the power to pass interlocutory orders pending adjudication of these questions. That is also, my lord, Supreme Court, which has been noticed by, my lord, the division bench. And, my lord, so far as section 92 is concerned, it has to be decided as a preliminary issue. But now, my lord, going back to the question, my lord, if your lordship sees the plaint, which is on record, which I shall draw your lordship's attention to, clearly says that, my lord, it is by reason of your wrongful use of the powers that you've usurped as a board of 12 governors, which you are now seeking to exercise alone, you have removed the 4 additional directors, although these 4 additional directors had equal say in the matter of their appointment removal during the term of their 1 year, during their 1-year term. And my lord, this was only to cite the manner in which, my lord, there was high-handed use of, my lord, these rights which had been usurped. But my lord, at the end of the day, my lord, the first 28 pages of the plaint are devoted to say that this is the scheme, this is how the scheme has become unworkable, this is how the scheme must be modified today. And my lord, it is now, my lord, also brought on record that, my lord, so far as the Lamartine schools of Lucknow are concerned, my lord, similar situation had arisen. Their entire board has been reconstituted with, my lord, of course, Muslim, Christians and non-Christians as well. Well, that is, my lord, a matter of record. It is now a part of the constitution of the Lamartine schools of Lucknow. Now, my lord, at the end of the day, my lord, the order that was obtaining was the order which says that, my lord, ultimately they will not appoint any new governors. And, my lord, ultimately they shall not take any decision except on the matters which concern the day-to-day running of the school. Now, my lord, now coming to the impugned order, if your lordship sees what has weighed with the learned single judge, in, my lord, ultimately dismissing the suit itself. The impugned order, my lord, is in the memo of appeal.
So the division bench of Justice Boshak sent back the matter with limited protection.
Yes.
Yes.
And said that go back and consider the matter of framing of the scheme there. Now, my lord, when we come back, my lord, they urge the points of section 92 again. They urge the point of, my lord, the suit being disposed of in its entirety by the framing of a scheme again. They urge the point saying that you can't ultimately pass an interlocutory order while the question of maintainability is being raised. All these points are taken. And, my lord, the matter is heard and argued exhaustively. Now, my lord, ultimately, if your lordship now sees the impugned order, well, that is also at page 49 of the stay petition. It is also in the memorandum of appeal. Well, I don't think it is necessary to, my lord, trouble your lordships because, my lord, well, if your lordships look at
57.
Well, at paragraph 28, well, at some of the submissions made on behalf of, my lord, the defendants. Just, my lord, some of the submissions made on behalf of the defendants. Well, Mr. Muralidhar, previously Justice Muralidhar, my lord, he was appearing, my lord, for the bishop. Well, at paragraph 28, Mr. Muralidhar submits that the first equity suit number such and such of 1967 was never decided. My lord, this is the suit of equity suit. The first equity suit of 2602 of 1967 was never decided. Paragraph 28. No. This is not, in fact, the old equity suit. Well, this is only a suit. Equity word has been wrongly used here.
That's the one regarding which there is some controversy.
Yes. So Mr. Muralidhar submits that the suit number 2602 of 1967 was never decided and adjudicated finally. He submits that even though there were only 3 out of 12 Christian members who were functioning as ex officio board of governors, the court held that the intention of the testator was to establish a school for the education of Christian boys and girls, their entrustment of the management of the said school to ex officio governors who profess Christian faith was quite proper and is recognized by the provisions of the Constitution under Articles 29 and 30 of the Constitution. Mr. Muralidhar submits that neither in the original will nor in the subsequent decrees prescribes any quorum of the board. No. কিছু আছে নাকি ফিক্স আছে নাকি আচ্ছা আর ফিক্স নেই কিছু 3.5 ক্ষেত্রে 3.5 মানে
Tushar, we have fixed a matter. Is it Mr. Joyanto Mitro's matter at 3:30? No. 3:15. Which one?
Interesting section 34. For hearing Mr. Dai.
Oh, I see.
That's fixed at
3:15. Mr. Lahiri is here. When will you come? When will you come back, Mr. Shah?
I can, my lord, tomorrow, second half, your lordships will not be sitting. Well, first half, I am, my lord. No, Monday, I mean, Monday. Well, Tuesday.
Amraj. Tuesday.
Tuesday, man.
Monday. You shouldn't take much more time.
No, I will not take, because, my lord, we are not at the final hearing of the appeal. I want, my lord, interlocutory orders now. I want stay of operation of the decree so that I can, my lord, press for, my lord, the framing of a scheme which is an interlocutory order.
Okay, first of all. Or at least the earlier order will revive the interim protection that was granted. If you succeed.
Yes, yes, of course.
Yes, come back on Tuesday. Lekho. Mr. Jishnu Shah, a learned senior advocate representing the appellants, has argued at length. Stop. He does not conclude.
Can I make one suggestion? I also appear for a respondent supporting Mr. Shah.
You appear for whom? Secretary?
Respondent number, yes.
The dismissed secretary.
Dismissed secretary. But if it's possible, I tell you, Lordship, only because there's a sense of urgency, I'm supporting him. He has little difficulty in the morning tomorrow. If it otherwise commends to your Lordship, I can make my submissions tomorrow. Only for Lord, we are in the same. We are in Lord Singh.
Well, then we'll proceed on the basis you have concluded.
No, Lord, he has not.
No, Mr. Bachawat, it becomes a little difficult. We have handled several cases together.
No, that's all right. That's all right. No difficulty.
You can take
I
off
tell you, Lordship, why I said so. Not the vacations are
start
impending.
from
There's
where
little
he has
time.
ended.
That's all.
You can start where he has ended. Covered the points, other points. I mean, you'll place the judgment, the relevant portions of the impugned judgment.
In that case, my lord,
You're for the
then I'll come back on Tuesday.
On
Tuesday, my lord. Let us not create.
Does not conclude. Paragraph as agreed by and between learned advocates for the parties. Let this matter be listed again on Kobe?
Tuesday,
May 20.
Does your lordships may fix some time if it is convenient to your lordships?
Last week, difficult, sir.
As it pleases your lordships.
Last week before vacation, very difficult.
Grateful, my lords.
তাহলে আমি শেষ করে দিলে আমি শেষ করে দিলাম তাহলে ইন্টারভিউ অর্ডার প্রেস করতে পারি ঠিক আমি প্লেন্টি পাচ্ছি I will very quickly conclude on Tuesday so that I will not take much time over there, because I have almost.
Once you conclude, Mr. Bachawat, Mr. Banerjee,
very short. I'll give a one-page.
We are naturally very.
One page.
Do not give notes.
One page.
I think the revival of the interim order is very important. That's why
the interim order needs to be there. That's the only thing.
But nothing is considered in the judgment, and they've taken advantage of the dismissal.
In fact, your lordships, can pass an interim order upon considering only the appellant's submissions also.
Hey, Kaushik. Weekend ta gelo, eta diye dio file ta.
Weekend ta gelo.
Okay.
Commercial division, please matter item number 9.
কোথায় গেল? আজকে আসবেনি, 9 তারিখ আসবে। না তুমি কেন দেখছো আমার?
Mr. Sen is opposing Mr. Lahiri.
Yes.
Go on till the rest of the day.
Till 4:30. You have no Daya Maya? Released. Released. Released.
Keep it at 3:30 so that Mr. Lahiri does not take more than an hour. On the understanding he would finish in an hour.
Very well. Commercial.
Act লাগবে না, act লাগবে।
Electricity. Mr. Sinha is for the respondent.
না, রিসিভ করবো না। একটু না এই ভলিউম 7 অফ রেকর্ডস অফ প্রসিডিং যেটা অ্যাওয়ার্ডটা আছে একটু দেবে। রেকর্ডস অফ প্রসিডিং আলাদা রাখা আছে। রেকর্ডস অফ প্রসিডিং দু রকম আছে, একটা রেকর্ডস অফ প্রসিডিং আছে, একটা ইন্ডেক্স। এগুলো না, এগুলো একটাও না, এগুলো সব নোটস। পারবো এই যে ইন্ডেক্স অফ রেকর্ড অফ প্রসিডিং ভলিউম 7, এই যে ইন্ডেক্স অফ রেকর্ডস অফ আরবিট্রেশন প্রসিডিংস, ওটা পেপার বুক আলাদা কিন্তু। না, এটা পুরোটাই ইন্ডেক্স অফ রেকর্ডস বলে আছে না। অ্যাওয়ার্ডটা আছে তো, একবার দেখি পেজ 2103। হ্যাঁ, এই তো অ্যাওয়ার্ড, এটাই অ্যাওয়ার্ড। both but this volume has the award. Please my lord, but kindly takes page 2103.
Your 34 was dismissed.
Well, it has page number 2103.
Yes.
Which is the award, my lord. The awarded sum is 232 crores 44 lakhs 82,000 odd. And my lord, that has to be paid with 9% interest from the date of the award till recovery. Now, my lord, kindly comes to page 2024, where the arbitral tribunal had framed the issues.
Yes.
The first issue is whether the termination of the agreement dated so and so by the claimant is legally justified and sustainable. The next is whether the railway circulars dated 26/9/2008 and 3/2/2011 unilaterally altered the basic structure of the agreement and is in violation of clause 12 and 16. Then whether the part of the claims formulated by a barred by laws of limitation. Then, my lord, the next part is counterclaim, and then, my lord, the main award is regarding claim 5, where, my lord, there are 4 numbers of heads in which the award has been on first 3 heads the award has been passed. Fair market value of 122 numbers of railway box and wagons and 2 8-wheel road good wakes rank. A report of the revaluation of rolling stock, annexure DD. Loss of freight rebate as per calculation sheet annexure FF, and loss of profit as per calculation sheet annexure KK. Then cost, well, Roman 6 was not awarded, and then interest, my lord, interest and award place for. Now, my lord, on the last occasion, I had argued, and I want to refresh, that section 37, the court under section 37 is akin to a court under section 34. So whatever a court under section 34 will look into the award as to perversity and the grounds under section 34, the section 37 court will also look into those grounds as enumerated under section 34 of the Act. So the scope of 37 is not narrow towards only the judgment of section 34, but also towards the perversity of the award. If the award is so perverse and it has not been considered by the section 34 court, the 37 court can go into that part of the perversity of the award. So, my lord, before this 37 court, we are also challenging the award itself. So, my lord, the touchstone of this section 37 would be also to see that the award is sustainable or not. Well, on that basis, I had argued on the last day on the ground of limitation. And why I had showed, my lord, today, the issues is that, my lord, issue number 2 relates to the railway circulars dated 26/9/2008 and 3/2/2011. And, my lord, I had argued on the last occasion that the section 21 notice as issued by the respondent here and the claimant before the tribunal was dated 3/10/2016, and they had,
which page?
That is in the compilation of relevant documents.
Achha.
We have this is the award, my lord. This has the award and the supplementary award. And, my lord, this is page 51 and 52, my lord.
Of compilation?
Not 51, my lord. এই যে কত কত একটু দেখে বলতো আমাকে, আমার এখানে পাতাটা নেই। I'll just
There are several page numbers.
No, these are page numbers of the volumes of the, but on the side the page numbers are there. My lord, kindly takes. Yes, page number 45.
In ink, blue ink.
Yes, yes.
Notice.
Which is the section 21 notice, my lord, dated 3rd October 2016.
Yes. All right.
Now, this my lord, notice states about, but in the second page, clause 9, we terminated the agreement dated 9 January by letter dated 17th June 2016. Since the railway has been using our wagons for 6 years, 7 months, we are entitled to profit. And in view, we have to sell at a price. And without prejudice, accept our sell. Then no reply. Modify. Kindly takes paragraph 14. The modifications of the said WIS policies of October 26, 2007, October 29, October 29, 2007, September 26, 2008, February 3, 2011, and August 1, 2013 has prejudiced us, and we are not allowed to use the REX as per the agreement. The alteration to WIS policy is without jurisdiction, and as per the WIS policy, no chance has been made. I have shown the issue number, the 2 circulars were taken by the tribunal and other circulars were not taken by the tribunal, as has been alleged in the notice. So only the 2 circulars were taken by the tribunal were September 26, 2006 and February 3, 2011. So the other circulars being restrictive or not was not considered, and they have not challenged that part also before any forum. But my argument was that the September 6, 2006 and February 3, 2011 circulars, to challenge that, they had to challenge it within the 3 years of the issuance of the circulars. And they have not challenged it within the 3 years of the circular, and they have challenged it only on 3rd October 2016, which is beyond the period of limitation.
Yes.
Now, I have also argued, my lord, on the last occasion that September 26, 2006 circular, the claimant respondent were well aware about that. They used the WI scheme for 9 months on the basis of this 2006 circular. So they cannot approbate and reprobate on this circular, September circular of 2006. Whatever circular of February 3, 2011 also, which was considered by the tribunal, would not have been, my lord, also challenged after 3 years, beyond 3 years. But even if we take the challenge of August 1, 2013 circular, the August 1, 2013 would end on September 30, 2016. So this notice is again barred by limitation on basis of order August 1, 2013 circular also.
End on 31st July, not September.
July. August 1, 31st July. So this also bars. And my lord, I have argued on the last occasion that a beginning of an arbitration starts with a section 21 notice. And Limitation Act applies to arbitration proceedings. And since Limitation Act applies to arbitration proceedings, the entire fulcrum of their argument that we have terminated the contract since these circulars were amending circular without taking our consent. duly affected our agreement, and therefore we had right to terminate. When I had placed the termination clause.
This point you argued before the arbitrators.
Yes. Issue was framed.
What did the arbitrators say?
Arbitrators said it's a continuing court of action, so 55 will apply. Article 55.
And learned single judge agreed with that.
With that. Well, the learned single judge agreed with the entire arguments of the tribunal. And though, my lord, 136 was not discussed in so and so, but why did the cause started here? Because, my lord, what had happened was this WI circular was all pan-India circular. Now, two of other parties had filed a case before the Delhi High Court. Now, Delhi High Court in a writ petition ordered that these two circulars, which is made into an issue in this arbitration, was held to be restrictive. It was challenged up to the Honorable Supreme Court with a division bench and to the Honorable Supreme Court. And the Honorable Supreme Court ultimately upheld the contention of those petitioners, those writ petitioners, before that court. And, my lord, had held that these two circulars were restrictive and
quashed.
And the termination of agreement was upheld. Now, my lord, all those persons who had filed the writ petitions before the Delhi High Court had terminated the contract within the time period, within limitation. Now, these people waited for the Delhi High Court judgment, and after only passing of the Delhi High Court judgment division bench, they thought it fit to come and say, no, we are also base our case on the Delhi High Court judgment. So, we also say that these circulars are affecting the contract, and therefore clause 16 of the clause 12 of the termination clause of the agreement applies to us. Now, my humble submission would be that a party challenging their right in a case before a court, that party's case is not judgment in rem, but the judgment in personam. A party who is aware about his rights has to take the action within a period of limitation and cannot just jump on the back of the party who has already taken the right and got an order in his favor. So, waiting for the Delhi High Court and the Honorable Supreme Court declaring those two circulars which was dealt with by the tribunal to be restrictive and allowing a party to terminate the agreement according to clause 12, the respondent couldn't have slept over its rights.
Yes.
While discussing on issue number 2, that is the railway circulars unilaterally altered the basic structure of the agreement or not, the tribunal heavily relied upon the judgments of the Delhi High Court. The arbitral tribunal heavily relied upon the Delhi High Court judgments. And while formulating the limitation clause, it said that it was a continuing breach, and therefore continuing breach, Article 55 of the Limitation Act applies, and therefore it is the claim is within limitation, so there is not barred by limitation. On continuing breach, I would say that there was no breach of contract at all.
Yes.
And as such, the event of termination, which is under clause 12 of the agreement governing the parties,
Yes.
did not give any consideration to the breach of contract, that on a breach of contract you can terminate. The termination clause was that if the investor goes into liquidation or there are alterations or deletions in the scheme, the clause was that upon termination by the investor or the claimant, they can
Which clause?
Clause 12, which is that the agreement, agreement is starting at page 5
Of
this compilation, my lord.
Yes.
Termination is not very
Yes, page 10, which can't be read at all.
Can't be read, my lord, but I can quote, my lord. This says, in the event of termination of the arrangement between the investor and on account of liquidations and stroke merger with the other company, or due to alterations stroke deletions in the scheme, the ownership of the wagons will remain with the investor. However, the investor shall have the option to sell the wagon to the Indian Railways at a mutually agreed price.
Please give us a typed out copy of that next day.
Well, we'll give one. The important clauses of the agreement, my lord, are clauses 1, railway agrees to move 2 numbers of box and wagon rakes and 122 wagons, including 4% spares for each rake, along with 2 brake vans procured by the investor either through Ministry of Railways or approved wagon builders of India through the wagon builder of foreign countries, subject to terms and conditions hereafter appearing. Now, my lord, kindly then takes 2.4. The commencement date shall be the day when the wagons of a rake are received by the railways from the wagon manufacturer, duly cleared and satisfied by the commission, and become available for service use. 2.5, freight rebate. What are they entitled to? The railway administration shall give a rebate on 10% of the normal tariff rates to the investors as may be notified by the central government from time to time. Now, kindly takes 2.8. Now, kindly also sees 2.7. Freight rebate mentioned under clause 2.5 shall be given for a period of 10 years from the commencement date. And commencement date comes in a later because they have to give all the wagons to the railways. Now, agreement shall remain in force for a period of 10 years from the commencement date. This is, my lord, 2.8. Now, kindly takes 4.1. The wagon procured under this scheme will merge and operate into the general pool of wagons of the Indian Railways, except BORB wagon, which will put to this is not required because this is BOXN wagons. So it will put into and merge in the general pool of the wagons. Now, next is very important. 4.2. The loading station of this rake will be at Borai Jamda and unloading station will be electro steel casting private siding at Shodhpur. So the start point is Borai Jamda and unloading is at electro steel private siding at Shodhpur. Now, my lord, next is, my lord, benefits. Benefits, my lord, kindly takes 5.2. What are the benefits that have been given? Freight rebate of 10% shall be granted for 10 years and a guaranteed supply of rakes at a rate of 6 rakes per month. And the guaranteed supply under the wagon investment scheme, which is this scheme, will be in addition to normal supply of rakes to such investors. So they are entitled to the normal rakes, but a guaranteed supply of 6 rakes per month will be given at a 10% rebate. Now, next,
For this, what does the investor have to do? For example, electricity.
they have to give two wagons. I read for 1.1, 2 wagons of 122, 2 rakes of 122 wagons. 2 rakes consisting of 122 wagons
each.
They have to give to the railways, which will be put into the general pool.
I see.
And for which they will get 6 rakes per month as their guaranteed supply, and they will get a 10% rebate on those rakes under the scheme. Now, my lord, kindly takes 5.6, which is also very important, my lord. The ownership of the wagon procured under the wagon investment scheme shall get merged, shall get transferred.
That you better give us a type
I'll
copy.
give a type copy. I'll give a type copy. So this has been photocopied so many times. Shall be transferred to the Indian Railways after 10 years. 10 years from the date in which the full rake has been handed over. So after 10 years, this rakes comes to the Indian Railways. So as on the 10th year from the date of commencement, the value of the rakes at the hand of the respondent claimant becomes 0. Why I am saying this is because, my lord, when the value of the wagon was considered, I have read the next clause on which basis the award was passed. It was taken that the value of the wagon is for 40 years. The value of the wagon was considered to be 40 years, and on that basis, my lord, the value of the wagon was considered by the arbitral tribunal, which was upheld by the Section 34 court. My lord, then, my lord, another important clause is 11.2. But in this clause, in this agreement, there is no mention as to what will happen in the event of earlier termination of the agreement by the investor, and what will be the rate that will be considered to be the value of the wagons. Because it says mutually agreed price. The termination clause says mutually agreed price. The only pointer as to value of wagon is in 11.2, which says that if a wagon is condemned, then, my lord, Indian Railways shall pay depreciated value as per income tax rules minus scrap value of the wagon. So the agreement only refers to income tax rate of depreciation only if the rakes are condemned. And my lord, kindly takes also 16.0, which will be harped upon, that any change in the terms and conditions of this agreement be made with mutual consent of the parties.
Yes.
So their case is these schemes that the notification that were issued by the railways from time to time, being those 2006 and 2011 notifications, were not done with the consent of the parties, and therefore it altered.
Those notifications withdrew some of these benefits or all the benefits.
No, it didn't withdraw. What it did actually was the phase-wise, my lord, usage of wagons were fixed by those rules. Like within 15 days, you have to place this much wagons. Within the next 15 days, you have to place such wagons.
Anyway, Please conclude today, Mr.
I try to conclude.
No. We have given you 1 hour, 15 minutes today. Please.
This is section 37, my lord. I have.
Maybe that doesn't mean you'll argue for 3 days. Sorry, we don't have that kind of time.
I understand, my lord.
We don't have that kind of time. Argue, give us written notes.
All written notes have already been filed.
Oh, filed. That's very good. Then just summarize your argument. We'll read your notes and don't worry.
Now, first point is on limitation, my lord. The second point, my lord, I would try to address, my lord, is how the award is perverse on the findings on issue number 5, which was the main issue. By which on 3 heads, my lord, the award was granted. That is on the fair market value of the wagons, the loss of freight rebate, and loss of profit. Now, on fair value of the wagons, the claimant placed an evidence of an expert who had taken, my lord, the basis of such valuation on the inter-railway transfer of assets. A formula formulated under the inter-railway transfer of assets.
Yes.
Now, following that formula, though he was asked that, did you see the agreement? Did you look into the main agreement? And how have you related to this inter-railway transfer of assets which doesn't form the part of the agreement? He stated that, no, this is the basis how railway transfers from one railway to another. Now, we are completely forgetting the fact that this inter-railway transfer of assets is on book value, is not on actual value.
Yes.
And a private third party claiming the value of the wagons, if once sold, on the basis of the value which inter-railway transfer happens, which is beyond the agreement, could not have been looked into by the tribunal.
Yes.
Again, my lord, the valuer had valued the wagons to be at 40 years. And my lord, I had showed before this honorable court that on the 10th year, the value becomes 0 at the hand of the claimants. So if the agreement ran for 10 years, then the value of the wagons became 0 at the hand of the claimants, because it would have been merged into the railways. So the valuer valued it at 40 years, and my lord has seen the termination was after 7 years, 6 months or something. So completely, my lord, this valuation, which was considered by the tribunal, was perverse and beyond the agreement, and my lord, beyond even the basic consideration that the value should be nil at the end of 10 years. Because what would have been the right value, and my lord, any government, when any procurement is there, the depreciation is as per income tax and not as per, my lord, any formula which is outside the scope of the agreement. Now, my lord, while determining the value to be about 34 crores 88 lakhs 42,000 something, which is the value which has been considered by the tribunal. A complete reliance was placed on the judgment of the on the with evidence and the document placed by the expert has been placed by the claimant respondent. And there is no discussion in the award or in the section 34 application that the value becomes zero at the end of 10 years. So you're blindly following an expert's opinion, that too on a basis of a my lord, calculation which is beyond the agreement, my lord, is perverse in terms of section 34 of the Arbitration and Conciliation Act. Because the learned tribunal did not even go into the fact that what would be the real calculation of the value of the wagons when the wagon was used till 7.6 years and it had the lifetime till 10 years. Now, my lord, but kindly contemplates that the claimant had terminated the contract, and the combination of contract says it has been on mutual agreed price. Now, the claimant immediately filed the arbitration upon filing a section 11, so they did not give any chance for us to set up a price. Now, if the value of a product and the depreciation is not taken to be income tax, this will be a huge loss to the exchequer. And if this formula is to be taken into consideration, where there is only book value and nothing, then this formula would be highly prejudicial to the interest of the nation. So this is my argument on the value of the wagons. And next is very important is on loss of freight rebate. Now, I had read the clause 4.2 of the agreement.
Yes.
I had read the clause 4.2 of the agreement. We said that the loading station would be at Boraijamda at Jharkhand, and the unloading station would be at Electro Steel Castings Private Siding at Shodhpur. But this agreement was amended once or twice. The amended agreements are there. Now, my lord, what happened, my lord, is an admitted position that from December 2008 to March 2009, and from June 2009 to December 2009, that is about 3 and 6, 9 months, the claimant respondent was allowed to use the wagon investment scheme. Now, use this scheme as in they had to actually make a private siding at Boraijamda. And that private siding was not functional, they couldn't function. So they had asked us to provide a public siding at two different places at Borai Jamda and Barbil at Odisha. So by we had given them to load the goods at Borai Jamda and Barbil at Odisha for these 9 months. Now, after December, on or after December 2009, my lords, we had said that we cannot allow you to carry on with this thing unless you procure your site at Borai Jamda. Now, what happened thereafter was from 16/4/2010, there was a restriction of interstate mining from Odisha to other states. From 16/4/2010, there was a restriction of transportation of minerals from Odisha to other states. Now, for this, the transportation by the claimant respondent was adversely affected. The claimant could not, my lord, transport the iron ores as they would have thought they would do from Barai Jamda because they had no iron ores at their end. But this will be reflected from several letters in the year 2013, which was not considered by the tribunal or by the Section 34. But vital evidence, why this perversity is, vital evidences were not looked into. Vital evidences were not looked into as per Associated Builders versus GDA, that judgment, my lord. I will refer to the judgment later on. But my lord, what had actually happened was that after December 2009, the last of such letters issued by, my lord, the claimant respondent was at 4/2/2010. After 4/2/2010, there is no communication by the respondent asking them to use the scheme. And my lord, they could not have used the scheme beyond 6/4/2010 because the interstate transportation was banned. Whereas those documents we have annexed in the compilation of documents, my lord.
And you have referred to those in your written notes also.
We have referred to the written notes, my lord.
We'll consider those documents.
The serial number 11, 12 are the letters, my lord, for temporary permission for using Borai Jamda and Barbil, my lord. And then, my lord, 16, point number 16 are the letters from 2nd September 2009 till 18th March 2011. And my lord, 4th February 2010 is the last letter, as we said. And thereafter, 4th March 11 and 18th March 11 are the two other letters. Now, may I place the 4th? 4th February letter, which is at page 105. That's the compilation minute.
Yes, Mr. Lagi.
Kindly takes page 105 of the compilation, which is the letter dated 4th February 2010.
Yes.
Request for extension, my lord, the letter states that, my lord. So kindly take the last paragraph. We request for your immediate intervention in the matter in advising Southeastern Railways to extend the temporary loading of one deck from Barbil and another deck from Boraijamda under WIS till such time our private siding at Boraijamda is commissioned. Well, in 4/3/2011, the next page, we say that till date your siding has not yet been commissioned. Your request for extension of temporary permission for loading X Barbil and Boraijamda forwarded to Railway Board, but Railway Board has not considered your proposal. And then, my lord, they have write a letter on March 18, 2011.
Yes.
But after this, there is no letter, madam. That I want to use my WIS scheme, I have goods, please allow me. But there are no, my lord, letters from them. Rather than that, my lord, kindly takes the next few documents, which is 2013. This is January 29, 2013 document, my lord. Kindly takes 1, 2, 3, 4, 5, 6 paragraph. You are well aware about the present situation prevailing in the state of Odisha and Jharkhand, where interstate transportation of ores from Odisha to Jharkhand is restricted, resulting in acute scarcity of ore in Jharkhand, where mines are limited and capacity of utilization of sidings in Jharkhand are not being achieved. Though our private siding as Boraijamda has been commissioned, we are unable to operate from a siding due to non-availability of iron ores. They are asking for freight rebate when they do not have any ores. And the Arnet Tribunal completely believed on the chart being annexure FF and granted the entire sum there. And my lord, these letters were never considered. All those letters, my lord, I have shown, I have placed, my lord, which are appearing at point number 16 and 17 of the compilation.
Yes.
Well, I've in that those the index I've said relied, not relied. This is relied by the tribunal, not relied by the tribunal. Now this continues, my lord. I'll just raise the last of the letters, which on 16 September 2013, which is at page 115. There are similar letters were been sent, my lord. But it starts as private siding to serve electricity at Boraijamda and Chakradarpur. Electricity casting, a pioneering company in ductile iron pipe business since a few decades, wanted to set up a 2.5 MTPS integrated steel plant at Sinduri, Bokaro from promoting the company.
in conformity to the MU of declared so and so, anticipating the so and so, then comes that putting an adequate capacity of railway siding at Badanpit plant and private siding at Borai Jamda to serve the upcoming iron ore mine. Subsequently, railways revised the policy. At 2008, by circular number so and so, strict high cost of iron ore policy got enforced, huge demand of siding of iron ore traders, integrated plants. Subsequently, 2009, we are compelled to accept this siding as per new policy. Our ECL private siding was commissioned and opened for traffic in 2012. So 2012, they opened the private siding. Now, iron ore business was adversely affected from 11-12 onward due to reduced to negligible in 2013 due to government crackdown on illegal mining and export policies. And then, my lord, next page. Despite all odds, we have loaded the first rake on 28 from our private siding at Borai Jamda. And the non-availability of full rakes. And then they, my lord, say that they cannot load any goods because of non-availability of, my lord, iron ores. And my lord kindly then takes the next page, which is 118, which is annexure FF. So post January 2010,
Yes.
they have calculated that 12 rakes each on every month. Based on the railway freight and 10% rebate, and carried on till June 2016. This entire claim on basis of the freight rebate, the 10%, I said, what they should have got? 6 rakes per month, that is 12 rakes and 10% rebate. If they have no goods, to load at the site using the WIS scheme, they shouldn't get any rebate from anyone. But what they tried to show before the tribunal was they were loading goods at other places. Various, my lord, challans, railway receipts were produced before the tribunal. It is about 3 volumes of railway receipts are part of the records, my lord. When asked to them that are these belonging to the WIS scheme, the witness said, no, these are not WIS scheme, these are other challans. So if they do not load on WIS scheme, are they entitled to freight rebate? I ask myself this question. So from January 2010 onwards till 2013, which is the last letter, and 2010, my lord, the change of policy, they had no rakes to load from Borai Jamda, which is as per agreement has to be loaded from Borai Jamda at Jharkhand. This agreement says that this will continue along with other agreements. They have other agreements with the railways. So this is in addition to their agreements, their transportation of goods through railways. So to come under this agreement and under this scheme, they need to load. They could not load even a single load from January 2010 till the time that they themselves choose to terminate the agreement. And therefore, my lord, the entire basis of granting
The award on the basis of annexure FF is perverse to the documents filed before the tribe. And no discussions were held because, or was there, because these are all exhibited documents. There is no denial that these are not exhibited. I am placing for the first time before the Section 34 court. But I go on to say in this regard that with the regime of Section 34 and the strict interpretation of Section 34 that the arbitrator is the master of the evidence, an arbitrator has to interpret an agreement according to him, and if a separate interpretation is available, the arbitrator's interpretation of the agreement would be taken into consideration. The perversity conundrum has been very narrow now. And on those narrow scheme of affairs, only 34 an award is set aside. So, my lord, an arbitration before an arbitrator or an arbitral tribunal is not any more adversarial.
Not adversarial.
No. But it has now the arbitrator has to be an inquisitor.
In France.
That has to come in, my lord. This is the now since the arbitrators value of the documents and the evidence before it and the entire gamut of arbitration being supreme.
Mr. Diary, I may agree with you. It should be inquisitorial, but in Western Europe, you find that. As I said, France. But still not in India.
No, the scheme of the 34 has made the arbitration to be inquisitorial. Because arbitrator is the master of evidence. Arbitrator is the master of reading into the agreement. And no court under Section 34 would go into the evidence-taking power of the arbitrator or the interpretation of the arbitrator and would rely on arbitrators. Therefore, my lord, the system of arbitration in India would be an acquisitorial system and not an adversarial system. Because that's why, my lord, that's why the fine distinction has been made by judgments like Associated Builders that if any document was before the arbitration tribunal and was not relied, then it becomes perverse. What happens before an arbitral tribunal? What happens where all these documents are there before the tribunal? Maybe due to lack of competence of an advocate or whatever, my lord, these documents are not placed. Maybe in arguments or in notes. These are not placed. But arbitrators should have looked into these documents when they were before the arbitrator and not fully believed on the annexure FF and relying upon that no cross-examination was made. A basic part of the award was there was lack of cross-examination of the witness of the claimant respondent. But when documents are glaring before the tribunal, which are exhibited by both parties, then the arbitrator should have looked into those documents beyond the evidence or beyond the cross-examination. It was a duty cast upon the arbitral tribunal to look into these documents to find out to the finding which is missing from the, I'm sorry to say, which is missing from the award.
Just as a matter of interest, who was Railways nominee? Three-member arbitral tribunal. So,
As I remember, the Railways had not nominated.
We had no normal.
Railways had not nominated, but we had nominated Mr. Vikas Borchar. Railways did not nominate. The Section 11 court nominated their nominee, and then the presiding officer.
Presiding was
Justice Tarun
Chatterjee. Yes.
he had to go to Section 11 court because they did not nominate their nominee.
And that he was also a retired High Court judge.
Justice Raghunath Rai.
Retired
Very well. Any other point, Mr.
No,
Zaidi?
yes. The next point
These construction contracts nowadays, we have 30, 40 volumes of documents. What my learned friend is saying will change the entire jurisprudence.
Has to.
Next. Indicate the points. Yes. Indicate the points. We'll read your notes.
But the next point on which the maximum part of the award has been published is published on, my lord, the loss of profit as per calculation sheet annexure KK. Now, what was the loss of profit? What did they rely upon? They relied upon, the claimant relied upon two agreements dated 8/9/2009 and 6/10/2009 with one Sesha Goa. Two agreements for 2 months with one Sesha Goa.
Yes.
Which is the next document after annexure FF, my lord. The next two documents are the two agreements that were placed before the tribunal. That they had used this WIS scheme to transport goods for Sesha. My lord, I had already indicated the goods were to be transported from Baraijamda to, my lord, the private siding of the claimant at Shodhpur. Then, my lord, the agreement was twice amended. But the amended agreements are annexed. Which starts from page 13, my lord. Page 13 of the compilation, my lord.
Yes.
The first amendment was, hence the correct loading station of two rakes under clause 4.2 will be proposed private siding of electro steel at Baraijamda and unloading station at electro steel private siding at Shodhpur. So proposed that time that it was not constructed. But the next agreement kindly keeps over at page 16, second paragraph. Thereafter, some modifications are made with regard to inclusion of unloading station Holdia, right, letter dated so and so. And clause 4.2 stands as clause for the loading station of these two rakes would be proposed private siding of electro steel at Baraijamda and unloading will be at electro steel siding at Shodhpur and Holdia. So it is the siding of electro steel and not of any other parties. And the next agreement is next supplementary agreement was, my lord, for a few months. But again, page 19. According to my last few lines. Accordingly, clause 4.2 of the agreement stand modified as 4.2. loading stations of these two decks will be Boraijamda, Barbil, Goodshed up to 7/12/2009 as per temporary permission, and permanent loading site will be Holdia and so and so at Shodhpur. So my unloading site is at their private siding at Holdia and Shodhpur. The agreement does not speak that they can use this scheme for third parties. There is no letter from their side except these two agreements asking permission that I want to load for third parties. Other than these two agreements and the chart, which was believed by the tribunal, there is no contemporaneous document or letter to show that they had an agreement with third party which they could not meet up because they could not load under WISK. And in answer to question number 15, notes থেকে বলছি।
Yes.
On page 14 of my notes. The respondent's witness stated that purpose of entering into WIS agreement was movement of raw materials from mines to their factory. So questions were asked. It's not that the questions were not asked. And stated that in 33 that the uploading, unloading stations is at private siding at Shodhpur. Now, my lord, there is no iota of proof before this tribunal that due to lack of transportation of ore through WIS scheme, there was loss in the factory. There was loss at their production in the factory. They wholly relied upon these two agreements, which are appearing at page 120 to 123. And then, my lord, annexed JJ, which is at page 124 onwards. 124. KK টা আবার দিয়ে দিচ্ছিস কেন বাবা? No, KK, sorry, my lord. Sorry, not annexure JJ. Annexure FF, KK. KK which is at 125. Completely believed in this loss of profit calculation without actual showing of loss of profit, except those two agreements with Seshaba. And the entire the award of loss of profit is in the tune of, my lord, about 144 crores. Out of the 232 crores award, the loss of profit is 144 crores. It becomes the major part of the award, madam. 114 crores, 232 crores. So 114 crores. And the basis of this was no questions was asked to the witness. The tribunal completely believing this, did not even find.
What is that case? Carapiet? No. 61
Yes,
Calcutta.
they've relied upon Calcutta in 34 also, in now also. But as I have said, my lord, as I have said, an arbitration does not remain an adversarial system of justice. Two agreements placed for the entire period of loss based on two agreements. The arbitral tribunal should have asked the claimant that what was your real loss. Since this is also interrelated to, my lord, no freight. Since the arbitral tribunal did not look into no freight, could not have looked into that this freight would have been used for third parties. An arbitral tribunal didn't even look into the fact that they were not entitled to give it to third parties.
Yes.
So the entire, my lord, award on this loss of profit is completely perverse and without any findings as to the truth and true estimation of loss of profit, as was placed before the tribunal by the claimant, based on two agreements which were non-substantiated with a third-party agreement. But these are on these portions. What then? My another part of the argument is that the tribunal had gone into the private siding dilemma on a great detail in the award. Now, the agreement says
Koushik, okay. Original site list. It original site.
kindly. No. Yes. So,
Mr. Rahimi, that's it then?
No, I have two.
What do you have?
Points.
We told you, you have 1 hour, 15 minutes, Mr. Lahiri.
It's a huge award, my lord. I have to sustain.
Oh, just because it's 232 crores, you have to speak for 2 days.
No,
how much more time will you take?
But I will take half an hour more. I'm going to little supplement by the learned ASG. Oh.
No.
And on the last day,
no. Then let learned ASG submit. This relay race, we don't believe in.
I understand.
We'll give you half an hour between the two of you. Please understand, we have a time constraint, Mr. Lahiri.
I understand.
You don't. Otherwise, you would have cooperated by being precise in your submission. We are repeatedly saying, make your oral submission concise, give us notes, say everything you want to say in your note. We'll go through the notes.
I've tried to be as concise as possible, madam.
কালকে হবে? The first half, Khali. Mr. Sen, your matter will be the number 2 item under the heading appeal from orders. Which number 1 we are hearing Mr. Joyanto Mitro in a matter. That is number 1 today. Yours is number 5 or 6 today, but it will be number 2. Tomorrow, Monday, every day it will be there, whenever it is called on. So that you can finish your argument this side of the vacation at least.
But this matter, my lord.
Yes. Why?
We come back on 9th of June.
Why?
There's a request from the ASG, my lord.
No, Mr. Light, this is not fair to us. We will forget everything. What is this?
We had mentioned the matter on the last.
What we had mentioned the matter?
On the other side.
Then why did you take 1.5 hours to 1 hour 15 minutes today? We should have said, no, we want an adjournment. Sorry. This is not fair to us. As we say, right? Mr. Lahiri, learned advocate representing the appellant, resumes his argument, but does not conclude. Stop. Paragraph, list the matter. Kalke rakchi na, Monday. Tomorrow it won't happen also.
On Monday, I have some difficulty. Tuesday, my lord, I have some difficulty on Monday. Monday is 19th. No? I have some difficulty. There's a fixed matter. Tuesday, I can.
What do you mean there's a fixed matter? What are you doing here?
This is also fixed matter. Kindly, can be accommodated till Tuesday.
Tenth, Tuesday?
20th.
No, Tuesday morning. I can do the matter. I have.
Oh, Kuri, sorry then. Tuesday. As the second item under the heading appeal from orders. এটা বলবো না কারণ ধরো যদি তার আগে ওইটা সেদিন শেষ হয়ে যায় তোমাকে বলে রাখলাম Please understand our predicament.
But if your lordship keeps it on Monday and Mr. Lahiri is not otherwise engaged, we can have the matter heard.
We'll keep it on Monday. If you are free, come.
But I will hold my kindly accommodate me on Monday. But Tuesday I will do that. I would not want to embarrass.
Mr. Sen, all we look for is cooperation. If that is not forthcoming, what can we do? Chalo. Mongolbar.